All right, looks like we got everybody.
Your Honor, may we briefly be put in a breakout room with opposing counsel just to confer on some pretrial matters?
Well, I don't. We were supposed to start at 9 o'clock, and so it's 8:59. So I'm guessing this is going to be some motions limiting.
Yes, Your Honor, we have a demonstrative that we'd like to show them ahead of time. Just to clarify with opposing counsel that it'll be acceptable for us to use that demonstrative in trial today.
Okay. And they haven't seen this yet?
They have not yet, Your Honor.
Why don't you go ahead and just show that to them on the screen right now, since we're about to start here and we need to get started at 9.
Okay.
And then we can certainly address it if there are any matters as well. And we'll get the go sheet up as we do some conflict checks. All right.
So for opposing counsel,
see.
There's just a blank table. It's going to be filled in during Renard's testimony to help the jury follow along with that testimony. So as testimony is elicited, my co-counsel will be in real time typing in just various aspects of the testimony to highlight them for the jury.
Okay. All right. I see that we have all of our jurors. I will ask the jurors, look at our advocates that are on the screen, and please let me know if you have any conflicts with any of the advocates that you see.
I do not.
I do not.
I do not.
And then, okay. All right. Sounds good. All right. We are here for the 4th round of this year's Summit Cup tournament. Will the attorneys please enter their appearance?
Good morning, Your Honor. My name is Madeline Izurdiaga, and I represent the plaintiff, Cam Donaldson.
Good morning, Marisa Kovacs, also for the plaintiff, Cam Donaldson.
Good morning, Your Honor. My name is Karna Kajar, and along with my co-counsel, Robert Fairbanks, we represent the defendant in today's trial, Ms. Karen Baja.
Thank you, counsel. All right, the live stream is already going, and if I can have all the advocates as well as the witnesses please turn their video on and raise your right hand. Please indicate by saying "I do" if you swear to abide by the rules of this proceeding and to conduct yourself in a manner that is honorable to this forum.
I do. I do.
All right. We are now calling the case 082263, Cam Donaldson versus Karen Baja. We will start with preliminary matters from the plaintiff.
Your Honor, we have a few housekeeping matters as well as a motion eliminate before we begin.
All right, go ahead.
First, Your Honor, may we assume that all objections are made at a constructive sidebar outside of the hearing of the jury?
Yes.
Second, would you like expert witnesses to be tendered?
Yes, please.
Finally, in terms of our demonstratives, how would you like both counsels, both sides to approach making the demonstratives? Is it all right if we briefly turn off our cameras and take a quick break to create the demonstrative?
Are you referring to demonstratives that you're going to make with your witnesses, or what type of demonstratives are you talking about?
Yes, with the witness, Your Honor.
You can make those demonstratives with the witness as you're doing your direct live on screen.
Thank you.
Any other housekeeping matters from the plaintiff?
No more housekeeping matters, Your Honor.
All right. Any housekeeping matters from the defense?
Yes, Your Honor. First, due to the virtual nature of this trial, may we assume that opposing counsel and witnesses have any exhibits that are identified throughout the trial already in front of them?
Yes, I have a copy of the case packet. So if you're referring to an exhibit or something in that case packet, if you can give me the page number, that's the easiest way for me to pull it up. But I assume that all counsel have a copy of that as well as the witnesses. And so if you're referring to a certain page or an exhibit, they can refer to that. And then if it's admitted, we can display it for the jury at that point.
Yes, Your Honor. And may we remain seated during objections due to the unique constraints of a virtual trial?
Yeah, either side, and this goes for any part of the trial, given that it's over Zoom, whether you stand or you sit is up to each individual advocate.
And at this time, the defense would like to invoke Rule 615 to call for the constructive sequestration of all witnesses barring party representatives.
Okay, so apart from the plaintiff, is there any advisory witness from the defense?
Apart from the plaintiff, Your Honor?
Oh, I'm sorry, the defense. Sorry, the defendant.
Oh,
So the
no,
defendant
Your
will remain as the plaintiff. Any advisory witness for your side?
No, Your Honor, we do not wish to have any other advisory witnesses.
All right. What about the plaintiff? Any advisory witness on your behalf?
We're fine with this, Your Honor.
Okay. So the plaintiff and the defendant will remain in the courtroom, and the other witnesses will be constructively sequestered. Any further housekeeping matters from the defense?
Yes, Your Honor. Finally, may we assume that all witnesses are constructively sworn in?
Yes.
Your Honor, the defense is now ready to proceed to motions in limine.
All right. The plaintiff, motion in limine?
Your Honor, we have one motion. We move to bar any discussion of a lack of arrest, conviction, or trial for Karen Baja in relation to the death of Lou Donaldson. First, Your Honor, as you know, a civil proceeding and a criminal proceeding have different standards, and therefore we don't think that this is relevant. Second, Your Honor, Karen Baja's involvement in Lou's disappearance is the main issue in today's case. And therefore, we think that discussion of the criminal investigation into it and a lack of charges brought against her without either a member of the police department that looked into it or the prosecutor's office would be remiss in the fact that, as you know, there are things other than the standard that are considered, and whether or not the state's attorney's office would bring a charge against Karen. And because we don't have the prosecutor's office here today or a member of the Pioneer County Police Department that investigated Lou's disappearance, we don't think it would be appropriate to discuss the lack of charges or lack of arrest. And finally, Your Honor, as you know, this is an ongoing investigation. It is an active investigation. And simply because Karen has not yet been arrested does not mean that she won't be or that charges won't be brought in a criminal matter.
Response from the defense?
Yes, Your Honor. The defense holds that any such testimony, if elicited today, may be elicited by experts. Opposing counsel's concerns don't go towards the admissibility of this testimony. They go towards the weight. The jury should have the opportunity to hear testimony being delivered, particularly if it's delivered through the lens of an expert witness, presenting that testimony as a part of their expert opinion. And the jury should be able to weigh for themselves whether or not such evidence plays a role in their final determination.
May I respond?
What I'm going to do with that is I'm kind of familiar with the area that you're going to. I'm going to reserve ruling at this point. So specifically to hear what the expert has to say and whether or not any information either of the experts is relying upon to come to their expert conclusion is based on that. And so I expect either party that wants to get into this lays sufficient foundation both for the knowledge of this, but also for how this would play into their opinion. And then we can object at that appropriate time during that expert's direct examination, and we will decide whether it comes in or not at that point. Any
Yeah,
further
but-
motions in limine? Okay.
We have no further motions.
Defense?
Yes, Your Honor. At this time, the defense moves to exclude any mention of and exclude from evidence a letter authored by Samantha Lane. May I be heard?
Yes.
Samantha Lane is one of the witnesses who verified the will of Lou Donaldson. There was a letter that our expert, Chris Renard, has disregarded as a hoax and did not rely on in coming to any conclusions in today's case. The defense moves to have any mention of that letter, which is impossible to verify, as Chris Renard could not reach Samantha Lane after it was written, from evidence on the basis of lack of authentication, as well as on the basis of hearsay.
Your Honor, if I may be heard.
Yes, please.
As to the authentication point, under 901, experts can and non-experts can testify that a certain piece of handwriting is in fact authentic under 901B4, and that they can see the differences or similarities. Now, opposing counsel's expert, Chris Renard, took a look at some of the handwriting in this case, including on a will where Samantha Lane was the second purported witness, and would be able to authenticate whether or not he thinks it even looks similar. But Your Honor, more importantly, we intend to use that letter to go to the credibility of Chris Renard's testimony. Now, opposing counsel is correct. Chris Renard completely disregarded that letter, and that's the problem. In that letter, it shows that Samantha Lane was in fact coerced into giving testimony that Lou Donaldson did in fact sign that June 12th or June 14th, 2012 will. And therefore his disregarding of an essential piece of evidence would in fact go to his credibility and whether or not the jury can trust his testimony. And therefore it's important that the jury be able to hear that evidence.
All right. I'm going to make a similar ruling to the plaintiff's motion in limine, considering that this also goes to potentially a 703 issue. So we'll see what foundation is laid. This would be through cross-examination, and whether or not this expert relied on it or should have relied upon it. And I think that's the question if we're doing it on cross and coming to their conclusion. I can tell the parties I'm leaning towards admitting this, but I will reserve final ruling until I hear the proper foundation for it laid during cross-examination, I would expect during the defense's expert witness. Any further motions to eliminate from the defense?
Yes, Your Honor. The defense also moves to exclude the 3 statements made by Lou Donaldson on the temporary restraining order that can be found on page 55 of the PDF on 2 grounds. His statements constitute inadmissible hearsay, and they also constitute inadmissible character evidence under Rule 404A.
Your Honor, if I may be heard?
Yes, please.
Your Honor, would it be helpful if I shared my screen to show that document?
You can. I have it up here, but go ahead and show it so our jurors can, I guess, see it since they are scoring as well.
Now, Your Honor, this is the temporary restraining order I believe opposing counsel is referring to and the 3 statements herein. Now, 2 of these statements, I'm seeking a divorce from Karen Baja and I do not feel safe around Karen Baja, are non-hearsay under 803.3, then existing state of mind. First, I'm seeking a divorce is a statement of intent or plan that Lou Donaldson was in fact intending to seek a divorce from Karen Baja. And second, I do not feel safe around Karen Baja is a statement of mental feeling. He's quite literally saying, I feel unsafe around her. Now, as to the threat, the underlying threat from Karen Baja is not only non-hearsay as a threat, but is also party opponent. But the first layer of hearsay that the defendant, or Lou Donaldson, pardon me, actually heard this, we're not actually using that for the hearsay purpose, rather just as circumstantial evidence of Lou Donaldson's fear. Now, by way of background, this was dated on June 12th of 2012, just 2 days before a purported will from Lou Donaldson intending to give everything to Karen Baja was signed. It's our contention in this case that that will is fraudulent, and therefore any testimony as to Lou Donaldson's state of mind just 2 days before signing that will is circumstantial evidence of his fear. Now, opposing counsel has also made the argument that this is character testimony, but it actually doesn't go to any of those character traits that 404A prohibits. We're not seeking to show vices or virtues of Ms. Karen Baja. We're just going to state that, around the time of June 12th of 2012, Lou Donaldson was in fear for his life, and that doesn't reflect any positive or negative character trait on behalf of Karen Baja. But of course, we're happy to do a curative instruction that we don't intend it for that purpose if opposing counsel is willing.
So counsel, I understand the 8033 argument on sentence 2 and sentence 3. Do I understand you correctly that you also believe sentence 1 falls under that 8033 exception, or are you using some other?
Your Honor, we're only offering that for the non-hearsay
one.
purpose of showing. I apologize, Your Honor. I think my connection might be a little bit off. For the first sentence, we are not offering it under that 8033 exception. We're offering it as non-hearsay, as circumstantial evidence of Lou Donaldson's fear on June 12th of 2012. I apologize.
Okay. And reply from the defense.
Yes, Your Honor. As to the hearsay issue, there are actually multiple layers of hearsay here. So there are the statements from Lou Donaldson, and then there are the statements as recorded on the document itself. And both of those are hearsay and would need to be addressed. As to the character evidence, we believe this evidence is being offered to show propensity with past action, namely that Ms. Baja in the past threatened the life of Mr. Donaldson and made him feel unsafe, and acted in conformity therewith in the future. And that is an impermissible use of character evidence.
All right, here's what I'm gonna do with this document. Assuming obviously foundation can be laid for whatever witness you intend to get this document in through, I will allow sentence 2 and sentence 3 to be admitted into evidence. Sentence 1, we are going to constructively redact. I'm not expecting any party to redact on the fly here. It doesn't fall under 8033, and I don't think we can separate that statement from the truth of what it asserts. So 2 and 3 would be admitted, 1 would not be admitted, assuming that foundation is properly laid during the trial for it.
And Your Honor, just to clarify, the signature of Lou Donaldson as well as the date and the rest of the document, can we assume that's all in as well?
The only thing that I am having redacted is sentence 1.
Wonderful. Thank you, Your Honor.
Any further motions in limine from the defense?
The defense has no more motions in limine. Thank you, Your Honor.
All right. Let's proceed to opening statements, and plaintiff, whenever you are ready, you may proceed.
Good morning. Lou Donaldson's life was a classic rags to riches story until his sudden disappearance and death in August 2012. Now, it's no coincidence, ladies and gentlemen of the jury, that before Lou disappeared, his marriage to defendant Karen Baja was in trouble. In June 2012, in fear for his physical safety, Lou filed for a temporary restraining order against Karen. In July, just weeks before he disappeared, Lou told Karen he wanted a divorce. So on August 18th at 3 in the morning, Karen called her big brother, Deputy Sheriff Carl Bannister of the Pioneer County Police Department, the same police department that would later go on to investigate Lou's disappearance. Deputy Sheriff Bannister arrived at the Big Cat Sanctuary that Lou and Karen ran at around 3:45 a.m. And there, Karen had a meat grinder large enough to dispose of a human body and a stable of leopards, lions, and tigers. Lou Donaldson was never seen or heard from again, and that's no coincidence either. Now, before anyone else knew Lou was missing, Karen broke into Lou's office at the sanctuary and took his lockbox containing his last will and testament. Weeks later, Karen emerged with a new will and testament, a will and testament dated 2 days after Lou had filed for a restraining order against Karen. And this will and testament left everything in Lou's $5 million estate to Karen should Lou die or disappear. Karen had Lou declared legally dead and was the sole beneficiary of another $5 million from Lou's life insurance policy. Cam Donaldson, Lou's only child and employee, was left with no father and no inheritance. This case is about the intentional killing of Lou Donaldson by Karen Baja. Now, this is a civil case, and we must prove to you by a preponderance of the evidence, which simply means more likely or not that 1, Karen killed Lou, and 2, she faked the will and forged the signature to leave her everything. Now today, you'll hear from Cam Donaldson, Lou's only child, an employee of 20 years, who will tell you that Lou had a different will, a will that evenly divided Lou's assets. You'll hear from Taylor Pride, a forensic document examiner, who will tell you that the signature on the will Karen presented is forged. You'll also hear from the defense and the defense's own witness, who has 20 years as a life insurance investigator, will tell you that he cannot say the signature on the will is genuine. Now, Cam Donaldson lost her father when Karen killed Lou. She lost her job when Karen fired Cam just days after Lou disappeared, and Cam lost her inheritance when Karen faked the will that left her everything. Cam Donaldson is seeking restitution in the form of damages for her many losses. Now, I want to tell you about Lou. Lou was a self-made man who worked his way up from humble beginnings and used his newfound wealth to rescue animals. Lou didn't have much formal education. He was a car salesman, but Lou was a hard worker. And when he saved up enough money, he opened Wild Wildlife, a sanctuary for leopards, lions, and tigers. Now, in addition to Lou's love of big cats, he also loved to fly, and he had his own private pilot's license and some planes as well. Now, Cam Donaldson, Lou's only child, was Lou's child from Lou's first marriage, and also Lou's employee of 20 years. Cam handled his father's schedule, and he also kept the books for the business. On Friday, August 17th, Cam Donaldson said goodbye to his father at work and expected to see him again that weekend, or perhaps Monday back at the office at the latest. Cam never saw his father again. Now let's talk about Karen. Karen Baja didn't have much money to her name when she met Lou, who had already made his millions, but Lou fell in love with her. And they got married, and Karen joined Lou in taking care of the wild cats. Now, in addition to Lou, Karen had family in the area. Her big brother, Deputy Sheriff Bannister, a member of the Pioneer County Police Department, the very same department that looked into Lou's disappearance. Now, Lou and Karen, they fell in love fast. They got married fast. Their marriage was not perfect, and the cracks began to show. On June 12th, 2012, in fear for his physical safety, Lou filed a temporary restraining order against Karen. In July, he told Karen that he wanted a divorce. So on August 18th, just hours after Lou last saw Cam, and just weeks after Lou told Karen that he wanted a divorce, Karen called Deputy Sheriff Bannister at 3 a.m. Deputy Sheriff Bannister arrived to the Big Cat Sanctuary shortly thereafter. There, Karen had a meat grinder large enough to grind a human body if and only if 2 people could operate it, and a stable of wild carnivorous cats. Now, what happened that night is disputed. But what is not in dispute, ladies and gentlemen of the jury, is that no one has seen or heard from Lou Donaldson ever again. Now, before anyone knew Lou was missing, Karen broke into the office of the sanctuary and she took a lockbox that contained Lou's last will and testament, which evenly divided his assets. Weeks after Lou's disappearance and after Karen had broken in, Karen presented a new will, and this will, dated just 2 days after Lou had filed for a restraining order against her, left everything in Lou's $5 million estate to Karen should Lou die or disappear. Now, not only did this will completely cut out Lou's only child, not only did this will leave no money for the sanctuary that Lou had spent his life building, this will seemed to anticipate Lou's disappearance. Now, 5 years after Lou disappeared, according to Statesville law, Lou could be declared legally dead. And 5 years to the day after he disappeared, Karen Baja had Lou declared dead. And the very same day, she went to Summit Life Insurance, the insurance company that held Lou's policy, to get that $5 million payout. Now, when Karen filed for that payout, it prompted an investigation by Summit Life Insurance into whether or not Karen was responsible for Lou's death and whether or not the will was genuine. And today you'll hear from Chris Renard, the defense's own expert, who has 20 years of experience as a life insurance investigator, and who will tell you in his 20 years, having reviewed hundreds of wills, that he has never once seen the phrase, "should I die or disappear," in any other will. In fact, he'll tell you he found that language suspicious. He'll tell you he cannot say the signature on the will is genuine. He'll tell you that despite the fact that it is disfavored in his own industry, he relied on the word of Karen Baja, the sole beneficiary of the will, to serve as a witness to the authenticity of the will. He'll tell you it's possible the signature on this will is a result of someone copying Lou's signature. So why are we here? We're here because the defense is going to tell you something else. They're going to tell you something very different. The defense will tell you that Karen Baja, despite having cared for big cats for years, didn't realize until 3 in the morning on August 18th that she was out of food for some tiger cubs, and that she went at 3 in the morning to get tiger cub food at a gas station when her car broke down, and she called her big brother to pick her up. The defense won't have any receipts or evidence of a car repair to corroborate that. They'll tell you that Lou's disappearance the same night that Karen called her brother to the sanctuary at 3 in the morning is because Lou chose that time to take a flight to Costa Rica, and perhaps the plane crashed, or perhaps it didn't, and Lou is there right now, despite the fact that no one has seen or heard from him ever again, and despite the fact that none of his bank accounts were touched after his disappearance. They won't be able to offer you any proof of a plane crash. Now, ladies and gentlemen, this is a civil case, and we have brought this claim against Karen Baja for the intentional killing of Lou Donaldson. We must prove to you that it is simply more likely than not that upon finding out that her husband intended to divorce her and take away that $5 million estate and that $5 million insurance policy, Karen had 10 million reasons to kill Lou Donaldson. that she turned a sanctuary into a slaughterhouse, and that it's no coincidence that Lou's will seems to anticipate his disappearance because Karen Baja wrote it to be so. At the end of this case, my co-counsel, Madeline Izardiaga, is going to come back and ask you to find Karen liable for Lou's death and to award damages to Cam Donaldson, who lost his father, his job, and his inheritance.
Thank you, counsel. Defense, your opening statement whenever you're ready.
Yes, Your Honor. This is a case about a man who lived his life off the book until he went off the grid and wanted to make sure that he was off the hook. My name is Karnik Hajar, and along with my co-counsel Robert Fairbanks, we represent Ms. Karen Baja in today's case. Ms. Kovacs just came up here, members of the jury, and told you a story about an evil, conniving woman with a meat grinder, ready to commit the ultimate crime to get her hands on her husband's money. But when you hear the facts of today's case, you'll realize that this is a case about a man who lived his life off the books until he chose to fly off the grid, wanted to make sure that his wife was taken care of, so he'd be off the hook. When Ms. Baja takes the stand before you today, she's going to tell you about her relationship with her husband, Lou Donaldson. She's going to tell you that they met when she was hitchhiking, and like a knight in shining armor, riding it on a white horse, like he was her Prince Charming, he picked her up. She's going to tell you that he was her soulmate, that she loved him more than anyone. She's also going to tell you that this wasn't just the start of a romantic partnership. It was also the start of a business one. She's going to tell you how she got involved in Lou's business, the Wild Wildlife Sanctuary. Members of the jury, the Wild Wildlife Sanctuary is tucked away in a quiet part of Statesville. It's a place where lions, leopards, and especially tigers all make their homes. It's a place where Karen Baja had the opportunity to watch over them, where these beautiful big cats would eat, sleep, and even give birth under her watchful eye. Now, all of this isn't to say that everything in Lou and Karen's marriage was rosy. When Ms. Baja takes the stand today, she's going to tell you that much of Lou's family, and particularly Lou's son, Cam Donaldson, didn't like her very much. She's going to tell you about Lou's nature, about how Lou was a secretive man, a man who liked to live his life off the books, until he chose to fly off the grid, wanted to make sure that she was taken care of so he would be off the hook. I want to talk a little bit about what I mean when I say that he chose to live his life off the books. So you're going to hear today that while Lou Donaldson might have been the owner of Wild Wildlife, he was hardly the operator. You'll learn that most of the day-to-day of the business, from scheduling meetings to handling phone calls, was actually handled by Lou Donaldson's son, Cam. You'll hear that a lot of the care of the cats themselves ultimately fell onto Lou Donaldson's wife, Karen. You're also going to hear that Lou Donaldson liked to travel. You're going to hear that he had his own planes, more than anyone ever really knew. You're going to hear that he rarely registered his flight plans when he traveled. And that brings us to Lou Donaldson going off the grid. When Ms. Baja takes the stand today, she's going to tell you about how the year 2012 was a particularly difficult year in her marriage to her husband. She'll testify about how she found out he had a mistress in Costa Rica. Members of the jury, you're going to hear a lot about the night of August 17th, 2012, because Karen Baja will tell you exactly what she was doing that night, today under oath. What you'll learn from her is that she was taking care of tiger cubs that had been abandoned by their mother. That she realized in the early morning hours of August 18th, she needed more formula. So she got in her car, she went to the grocery store to pick it up. On her way back, her car broke down. She'll tell you about how she called her brother, who took her back to the sanctuary so she could finally take care of those cubs. But then Ms. Baja will tell you about the rest of August 18th. She'll tell you that she didn't hear anything from Lou Donaldson. She'll tell you she didn't hear anything from Lou Donaldson for the rest of August 19th. She'll tell you, members of the jury, that she didn't hear anything from Lou Donaldson ever again. Ms. Baja will tell you she waited 5 long years. 5 years hoping to receive a call or a text, a letter or a postcard. But she never heard anything. So Ms. Baja will tell you that seeking closure, she went to the courthouse and she did file to have him declared legally dead, hoping that she could learn to move on. But members of the jury, she did file for the payout on her husband's life insurance policy. And you'll hear from that life insurance investigator today, Ms. Chris Renard. When Ms. Renard takes the stand, she's going to walk you through her investigation in depth. She's going to tell you about how her CEO wanted her to look into the circumstances around Lou Donaldson's disappearance, wanted her to look into whether or not that will was authentic, wanted to make sure that Summit Life Insurance Company would have to pay that $5 million payout. Ms. Renard will take the stand and she will tell you that based on her investigation, she didn't find those circumstances suspicious and she didn't think that will was fake. Members of the jury, Ms. Renard will tell you that she thought that it was perfectly acceptable for them to pay that $5 million life insurance policy. With that life insurance policy in hand, with wild wildlife under the care of the woman who loved the cats the most, Mr. Donaldson could be off the hook with his wife taken care of. And at the end of today's trial, my co-counsel, Mr. Fairbanks, is going to come up here. He's going to walk you through all the evidence that you'll have heard today. He's going to ask you to think about whether this is a case about an evil, conniving woman with a meat grinder, or much more simply, that this is a case about a man who lived his life off the books until he went off the grid, wanted to make sure that he was off the hook. Thank you.
Thank you, counsel. Plaintiff, you may begin your case in chief.
Plaintiff calls Cam Donaldson, Your Honor. May I proceed?
Yes.
Can you please introduce yourself to the court?
My name is Cam Donaldson.
Cam, what was your relationship to Lou Donaldson?
He was my father.
Can you tell us about your father?
He was such a hard worker, a good man, a self-made man. He didn't have much education, but he worked his way up in life. He scraped up enough money selling cars. And when he finally had enough money, he decided to pursue his true passion, which was, animals. So he founded Wild Wildlife.
What was Wild Wildlife?
It's a sanctuary for big cats like lions, leopards, tigers, things like that. My dad loved animals.
How was your relationship with your dad?
Oh, I mean, we were close. I was his only child, and I was also his assistant at Wild Wildlife. We worked together for over 20 years. At the office, we would joke around and work together all the time. But he'd still invite me over for dinner on the weekends too.
Now, you said you were his assistant. What was your role as an assistant?
Oh, I mean, I did pretty much everything for him. I, scheduled his meetings, finances, did the books, all that stuff.
Do you still work there?
No, I don't.
Why not?
My stepmother, Karen Baja, she fired me a couple of days after my father disappeared.
How is your relationship with Karen?
I admit it. I hate her.
Why do you say that?
I believe she killed my father.
Now, Cam, do you recall an incident in the month leading up to your father's disappearance?
I do.
When was this?
About 2 weeks before my father disappeared.
Where was it?
In his office.
Who was there?
Karen and my father were in his office, and I was nearby, just outside.
How did you know they were in his office?
Oh, you could hear them through the door. They were arguing pretty loudly.
What did you see?
Well, Karen stormed out of the office first, and then my father walked out after her.
How did your father appear to you?
I mean, he was visibly shaken. I had quite literally never seen him this shaken before in my life.
What did you do?
I mean, I just asked him if he was okay.
What did he say?
Objection, Your Honor, calls for hearsay.
May I respond?
You may.
Your Honor, this is an exception to the rule against hearsay under 803 as an excited utterance. The witness has laid the foundation for his knowledge of these events, and furthermore, this statement, which I believe the witness is about to attest to, was given after, just moments after, Lou Donaldson had fought with his wife, and just weeks after he had filed a temporary restraining order against her in fear for his safety. So we certainly believe that this qualifies as an excited utterance.
And defense, any reply to that?
Yes, Your Honor. The statement, I have a good faith belief that the witness is about to make, does not rise to the level of a startling event or condition necessary for the 803 exception. It's a commonplace marital dispute. Additionally, I believe the statement opposing counsel is trying to elicit does not relate to that startling event itself.
May I respond?
Just so I'm clear, what is the statement that we are talking about?
Yeah, so the statement, Your Honor, is if anything ever happens to me, be sure to have the police look into Karen because she will be the one responsible for my death.
All right. Ms. Kovacs, I will let you lay some additional foundation as far as the 803.2 exception that I believe that you're trying to get this under. And then defense, you are free to object when she tries to elicit that statement after she lays that foundation, and I will make a ruling at that point.
Thank you, Your Honor.
Cam, were you aware of other issues in your father's relationship with Miss Baja?
I was. They had been fighting for some time.
Were you aware of any specific action your father may have taken?
I know that he filed for a temporary restraining order at one point.
Do you know roughly when that was?
Oh, I believe it was June 12th of 2012, I believe that was.
So the event you're alluding to happened perhaps a month later?
Yeah, that
Objection,
sounds
Your Honor.
about right.
I'm happy to rephrase, Your Honor.
Move to-
Okay, I didn't hear the objection, but go ahead and rephrase that, Ms. Kovac.
Could you tell us again, when did the event you're alluding to occur?
My father filed for the temporary restraining order in June 2012. The events at the office that we were discussing happened a couple weeks after he disappeared. So between the two, maybe about a month had passed.
I'm sorry, did you say a couple weeks after he disappeared?
I'm sorry, before.
Okay. So to be clear, you were at the office that day.
Yes.
And what did you hear?
Well, I heard them arguing.
At this point, I don't believe there's sufficient foundation for 8032. So absent any other exception, I'm going to sustain the objection.
May I be heard, Your Honor?
Yeah, do you have a separate basis to get it in for hearsay?
I would just like to clarify that we do believe that this falls into the exception to hearsay as an excited utterance because there is no time limit on when the excited utterance has to be said after an event. And certainly we believe that a threat by a spouse would be something that would linger. And therefore this fight that would happen weeks after the temporary restraining order and after Karen threatened his life would still be very much related to the initial events of the TRO.
And while I certainly agree there is not a time limit to 8032, I have yet to hear any testimony that when Mr. Donaldson stated this statement a month later, that he was currently under that stress, was excited at that moment when he was making it. So absent that foundation being laid, I'm going to sustain the objection.
Cam, could you tell me again, how did your father appear when you saw him?
Well, when he
Objection, Your
came,
Honor, asked and answered.
May I
Overruled.
respond? Thank you. How did your father appear when you saw him?
when he walked out of that office after Karen and him were arguing, he was visibly shaken. I had never seen him that shaken before in my life.
What was his manner?
I mean, he just really looked really shaken. I really can't describe it any more than that, just because, I had never seen him look that disturbed.
Now, I don't want you to tell me what he said, but when he spoke, how did he sound?
I mean, he sounded scared.
What did he say?
I'm sorry, Your Honor. Objection. This is the same testimony that the witness has already testified to.
All right. Let me get an offer of proof from either side. My understanding, at least from what I was hearing, was there is a initial conversation and this argument that he had where this witness saw him scared a month prior, and then the statement about if anything happens to me, look to the defendant was later. Am I mistaken? That was what I was gathering from the testimony. There was a month separating what he just described and the statement actually made by Mr. Donaldson.
No, Your Honor, that's the same day.
Okay. So what is this month prior argument that we've been talking about?
So the month prior was the temporary restraining order, which Cam knew about. But the same day that Cam Donaldson heard his father fighting was the day that he then saw his father, who appeared excited and agitated, and then offered this statement.
Okay. Defense? Any response?
Yes, Your Honor. Again, a marital dispute, and I think the testimony is going to show that these marital disputes at this point were not uncommon, does not meet the bar of a startling event or condition sufficient for the excited utterance. And additionally, the statement that the declarant made to the witness did not relate to that startling or that allegedly startling event or condition. It was a hypothetical statement.
All right. Given the testimony that I just heard, and I guess the connection of these two time periods and not being separated so far, I'm going to overrule the objection and allow the statement to be introduced.
Thank you. Cam, what did he say?
My father looked at me and he told me, if anything ever happens to me, be sure to have the police look into Karen because she will be the one responsible for my death.
Now, Cam, I know this is emotional, but do you recall the last time you saw your father?
Yeah, I do. It was Friday, August 17th, 2012, a day before he disappeared.
Where was it?
It was at the office, the wildlife office.
Who was there?
It was just me and him.
What was said?
Well, he told me that he'd see me on Monday, unless I wanted to come over for dinner on Sunday. He asked me if, he invited me over for dinner.
Objection, Your Honor, hearsay.
Your Honor, an invitation is not hearsay.
I think it is an exception to hearsay under 8033, a statement of plan or intent. So I'm going to overrule that.
Now, Cam, I want to talk to you about who you did see that weekend. Did you see Karen Baja that weekend?
I did.
Where did you see her?
It was at the wildlife office.
When was this?
It was actually that Sunday, August 19th, 2012, around 6 in the morning.
Why were you there at 6 in the morning?
Well, I live close by and I'd heard the alarm go off, so I just drove right over to see what was going on.
What did you see when you arrived?
Karen was there with somebody I didn't recognize. He had like a lock cutter or a bolt cutter of some kind. And then the police came shortly after I did.
Cam, I'd like to direct your attention to page 28 of the case file. Can you please let me know when you're there?
Okay, I see it.
Do you recognize this?
I do.
What is this?
It's a padlock from the front gate. When I arrived, it had been cut and I saw that it was cut. And I also saw, as I said, Karen coming out with another person who was holding some sort of lock cutter.
Your Honor, at this time, I move to enter this as Plaintiff Exhibit 1.
Any objection?
No objection, Your Honor.
It's admitted as Exhibit 1, and you may publish.
Thank you. Now, what was taken?
Well, Karen was also carrying a lockbox in her hand when she walked out of the office. It was a lockbox that I kept in a drawer in my desk at the office, and I kept that drawer locked.
What did you keep in the box?
My father's last will and testament.
Are you familiar with the contents of that last will and testament?
I am, yeah.
What was in the last will and testament?
Objection, hearsay, Your Honor.
Response?
Your Honor, first of all, the best evidence rule does not apply in this case because this document is missing. Under Rule 1008, the jury determines any issue about whether an asserted writing, here the will, ever existed, and this is determined in accordance to Rule 104B, which is the lower standard of evidence sufficient to support a finding. Here, we believe that we have secondary evidence sufficient to support a finding that Cam Donaldson, who maintained the will, was familiar with its contents and had personal knowledge.
Mr. Fairbanks, correct me if I'm wrong, was your objection hearsay or was that it? Or
it was specifically as to the contents of the will being hearsay.
Okay. And Ms. Kovacs, do you have a response to hearsay?
So, Your Honor, the Cam Donaldson has personal knowledge as to the contents of the will. He has kept the contents of the will in his lockbox, in the lockbox under his desk. And I can certainly ask another question to confirm his personal knowledge of it, but we do believe he has personal knowledge. I'd be happy to lay that foundation.
May I be heard, Your Honor? Just to clarify.
Go ahead.
I'm not arguing there's a lack of personal knowledge. I am arguing that the actual contents of the will are out of court statements offered for the truth of the matter asserted. So I believe that the plaintiff would have personal knowledge of this alleged will. I'm arguing any statements would constitute hearsay.
Okay. Here's my ruling on that. I understand the objection to be hearsay. As far as hearsay is concerned, I believe would fall under both an exception to hearsay, as it is a statement that affects the interest of property, as well as a will being a legally operative fact. So I'm going to overrule the objection to hearsay.
What were the contents of the will?
So the will that was in that lockbox, it split my father's assets 4 ways. It left 25% to me, 25% to my mother, 25% to Karen, and it also left 25% to a specific foundation meant to keep wild wildlife operational.
Cam, do you believe your father is dead?
Yes.
Why do you believe that?
We were really close. He literally told me on Friday that I could come over to dinner on Sunday. He never once mentioned any trip to Costa Rica or anything like that. It just wouldn't make sense otherwise.
Why did you bring this complaint?
Because Karen killed my father.
What are you asking for from Karen?
I'd like monetary restitution for the money that she inherited solely because she murdered my father and then forged a will. I mean, I'd also like some sort of monetary restitution for the pain, suffering, and everything that goes with the loss of a father.
Thank you. No further questions at this time.
Thank you, counsel.
Your Honor, may I be given a moment to swap my
Ross?
video feed?
Yes.
Thank you. Good morning. Good morning, Mr. Donaldson. I know talking about your father's disappearance is very difficult for you, but I just have a few questions. I want to start by talking about the relationship you had with your father. And on direct, you testified that you were involved in his business, and I want to be clear for the jury on how you were involved. I think you said you ran the day-to-day of his business.
That's correct.
You scheduled his meetings,
Yes, sir.
wrote the checks,
Yes, sir.
answered the phones,
Yes,
ordered the supplies.
I did.
You handled the financial records.
I did, yeah.
In other words, you ran the books.
Yeah, I suppose you could say that, sure.
So you were an important part of your father's business.
Of course, I hope I was.
But in terms of your father's personal life, your dad never told you about a mistress in Costa Rica.
No, he didn't.
You weren't aware of any mistress in Costa Rica?
To my knowledge, none existed.
Mr. Donaldson, I'd like to ask you about some of the other things you aren't aware of. You aren't aware of your dad having any US bank accounts other than the business account that you were familiar with.
No.
And you don't know if he had any foreign bank accounts.
No, I don't.
You don't know if he had any stocks.
I can't say that I do.
You don't know if he had any other investments.
No.
Any real estate he kept off the books?
No, I can't say that I know that.
I'd like to talk about some of the stuff you do know that your dad kept off the books. You know he bought and sold planes all the time.
He did, yeah, he let it fly.
And you know that most of the time he didn't register those planes.
Oh, I don't know about that. I mean, I know that some of his planes weren't registered, but to say most, I can't say that it was most.
So your father had planes that he did not register.
He did have some, yes, that's true.
And you know that your father sometimes flew without logging flight plans.
Rarely, but yes.
And you also know that he flew without a valid pilot's license.
Oh, I mean, I know that at the time that he disappeared, his his pilot's license was suspended, but I don't know that he ever flew with a suspended license.
So he had a suspended pilot's license.
Exactly. Yeah. So it makes more sense that he wouldn't have flown.
It's safe to say that you don't know all the different planes your father's flown.
No.
It's not safe to say that?
Oh, I apologize. I was confused by the wording of the question. I don't know all the planes my father's owned.
Thank you for providing clarity to the jury. Is it also safe to say that you don't know all the different places he's ever flown before?
Well, I wasn't with him on every trip, but he would always tell me when and where he was going. So, I mean, I know what he told me.
You know what he told you. So if he chose not to tell you that he was flying to Costa Rica, you have no way of knowing whether or not he did fly to Costa Rica the night that he disappeared.
I mean, I guess that's true, sure.
I want to finish by talking about your accusations against Miss Baja. I think on direct today, you just came out and said it. I think you said you hate Miss Baja.
I think that's a fair feeling to feel.
In fact, you said that you hate her so much, quote, I hope she is attacked and eaten by one of her tigers.
I did say that in my deposition about 1.5 years ago. I regret it, but I did say that.
You regret it now, but you made that statement because you were so affected by your father's disappearance.
By his death, yes.
And you were so affected that you hired an investigator to look into it.
I did, yeah.
But you didn't hire that investigator right after your father disappeared, did you?
No.
You didn't hire that investigator until about 5 years after he disappeared.
That's right.
And to make the timeline clear for the jury, 5 years later was about a month before your father was declared legally dead.
That's correct.
5 years later was also about a month before Miss Baja would have been finally eligible to receive the $5 million insurance payout.
I think that's right, yeah.
And to be clear for the jury, you weren't going to receive a dime of that.
No, I mean, the will that Karen produced left everything to her.
No more questions, Your Honor.
Thank you, counsel. Any redirect examination?
No redirect is necessary, Your Honor.
All right. Mr. Donaldson may be excused. And plaintiff, you may.
Yes, Your Honor. At this time, we call Taylor Pride to the stand. And may I proceed?
You may.
Thank you, Your Honor. Good morning. Could you please introduce yourself to the members of the jury?
Yes, my name is Taylor Pride.
What do you do for a living, Ms. Pride?
I am a private investigator. I currently work for and run Pride Investigations.
And what's your involvement in this case?
I was hired by Cam Donaldson to analyze the last will and testament of Lou Donaldson, specifically to determine whether or not Lou Donaldson had in fact signed the will or whether it was forged.
Before we talk about your work in this case in more depth, I want to talk a little bit about your career in education. Now, before founding Pride Investigations, did you work anywhere else?
Yes, I worked for the Pioneer Police Department for 18 years, excuse me, 2 years as a patrol officer and then 16 years as a detective.
When you were working as a detective, did you work in any particular units within the Pioneer PD?
Yes, for 6 of those years from 2002 to 2008, I worked in the economic crime unit.
And what does the economic crime unit do?
So I apologize, they investigate all sorts of white collar crimes, everything from embezzlement to fraud to forgery.
And what did you do when you were working in the economic crime unit?
So I investigated all of those things, everything across the board, but in particular, I spent a lot of time working with handwriting analysis, specifically investigating forgeries.
Can you explain for the members of the jury your education and training in regard to handwriting analysis?
Of course. I attended the American Association of Handwriting Analysis training. I was there and I was certified while I was there by the American Board of Forensic Document Examiners. It's the gold standard in my field. And then I obviously spent a lot of time working in the field while I was in the economic crime unit with the Pioneer Police Department.
Have you kept up with that training since you left Pioneer PD?
Yes, I continue to do 8-hour trainings on an annual basis. I also become recertified by the American Board of Document Examiners every 4 years. And then obviously I'm working in the field on a daily basis.
Ms. Pride, how many times have you testified as an expert like you are in this case?
About 15 times in the past 18 years.
So let's talk a little bit about your work and your method in this case. Now, what work were you specifically asked to do?
I was asked to analyze the signature on the last will and testament of Lou Donaldson and determine whether it was forged or not.
Did you know who the investigating agency had been before that time?
Yes, it was the Pioneer Sheriff's Department.
Okay. Can you outline for us what does somebody do if they're trying to figure out whether or not a signature is forged or not through handwriting analysis?
Yes. So we follow a pretty standard 3-step procedure. So we begin by collecting known samples of the individual signature. So in this case, we found those known samples. And then the second step in one of these cases is to look at the unique characteristics of those samples. And then finally, you compare those unique characteristics of the known samples to the question sample in the case.
Let's break that down a little bit. What were those known samples that you had of Lou Donaldson's handwriting?
So in this case, we had a copy of his driver's license, or specifically the signature on his driver's license. And then we also had a copy of his signature from a restraining order that he filed in 2012.
And were those known samples sufficient for you to understand the unique characteristics of his handwriting?
Absolutely, yeah, they were original copies. They weren't photocopies or anything like that. So they were very clear and easy to analyze.
Now, did you have sufficient facts and data to come to a conclusion in this case?
Yes.
Did you use reliable principles and methods?
I did.
And did you apply those sufficient facts and data to those reliable principles and methods?
Yes.
Now, without telling us your conclusion, were you ultimately able to come to a conclusion in this case?
I did.
Your Honor, at this time, we proffer Ms. Taylor Pride as an expert in handwriting analysis and forgeries.
Any objection or voir
No objection.
dire from the defense?
No objection nor voir dire, Your Honor.
Okay. Ms. Pride
All right,
is
Ms.
admitted as
Thank you, Your Honor. I apologize for cutting you off. Now, Ms. Pride, let's go a little bit through your analysis in this case. Now, can you tell us again, what did you use in coming to a conclusion in this case?
So a lot of different things. I mean, specifically, I was looking at the signatures. So I used the driver's license, the restraining order, and then as well the last will and testament at issue. But I also did take into account some outside factors to get the necessary context to come to my conclusion.
Would a demonstrative aid you in showing the members of the jury your analyses and conclusions?
Absolutely, yes.
Your Honor, at this time, we're going to go through and create that demonstrative that we talked to you about a little bit in housekeeping by having Ms. Pride go through the signatures that she used in her analysis and creating the demonstrative on screen, if that's all right with you.
That's fine.
Wonderful. Thank you so much, Your Honor. Now, Ms. Pride, I'm going to direct your attention to page I believe it's 40 of the, actually, let's go first to page 55 of the case materials, bait stamp number ending in 0016. Let me know when you're there.
I have that here.
Okay, and is that the signature that you used in coming into a conclusion, that temporary restraining order, as a known sample?
Yes, it is.
Okay, I'm going to go ahead and share my screen so we can go through this together. So is this that signature that you used?
Yes, it is.
Okay, I'm going to put a note underneath.
Objection, Your Honor, to the temporary restraining order being published in full to the jury prior to it being admitted to evidence.
So
Your
it
Honor,
has.
I apologize.
No. So it has not been admitted yet. I think I made this clarification on housekeeping. Given our forum, I'm fine with this method of putting it up here and laying foundation or doing what we need to do. We are assuming it is not published or admitted to the jury at this point, unless and until plaintiff's counsel elects to try to do that. So this is just laying foundation with this witness at this point.
Yes, Your Honor.
Yes, Your Honor. I'm going to go ahead and write temporary restraining order underneath here. Now, next, can you go ahead and go to page 40 of the case materials, bait stamp number ending in 007, and let me know when you're there.
I'm there.
Are these the two signatures, the driver's license signature, as well as the last will and testament that you used in coming to your conclusions?
Yes, those two match the ones that I used.
Okay, I'm going to copy and paste those over for you. Apologize for my lack of knowledge here. Just one second. All right, and does that accurately reflect those three that you used?
Yes, they do.
Okay, Your Honor, at this time, motion to formally publish the members of the jury as used for demonstrative purposes during Ms. Pride's testimony.
Any objection to the demonstrative on the left-hand side of the screen being published for a demonstrative?
No objection to the demonstrative on the left-hand side of the screen being published, Your Honor.
Okay.
We apologize to opposing counsel for showing that beforehand.
So the demonstrative can be published to the jury.
Okay. Now, Ms. Pride, let's go through this a little bit. Now, starting with those two known samples, the temporary restraining order and the driver's license, did you notice any similarities between those two signatures in the lieu of Lou Donaldson?
Yes, I did.
Okay, and what were those similarities?
So specifically, as you can see here, first the L in lieu, the top loop of the L in both signatures was smaller than the bottom loop. So that was the first thing. But secondarily, if you look at the O, both of the O's here have an extra loop, as you can see there. And then finally, the U on both of these signatures had a tail embellishment.
All right, let's go to Donaldson. Were there any observed similarities that you found between those two signatures?
Yes, specifically the second O in Donaldson in both of these signatures, as you can see here, was what we refer to in my field as a lazy letter, meaning it was just kind of tailing off at the end. It wasn't a completely formed letter. And then you can also see a similar tail embellishment here on both ends that is similar to the tail embellishment on the U in lieu.
Is there anything else about these two signatures that struck you as similar or being written by the same writer?
Yes, so in particular, it was clear to me that in both of the signatures, you can see that the letters are looped together. In both the Lou and the Donaldson, it goes straight from the L to the O to the U, from the D to the O. So not only are they looped together, but that shows me that the writer, in this case Lou, rarely lifted his pen, if at all, in these first two signatures. So that was the most striking thing to me.
All right, let's go to that unknown sample, the will at the bottom. Did you notice any differences between the temporary restraining order and driver's license versus that will?
Yes. So first, it was very noticeable that the will was a little bit more shaky. So it was definitely a shakier signature than the other two. So that was the first and most notable difference in this case. But secondarily, it was very clear to me that the writer of the will actually lifted their pen. You can see in the will that the D and Donaldson in particular, they not only lifted their pen, but they used 2 strokes instead of the 1 stroke that you can see being used in both of these first 2 Ds in Donaldson.
All right. Was there any other differences that you noticed between the will and the driver's license and temporary restraining order?
Yeah, so it was mainly just the shakiness, like I mentioned, and then the 1 stroke versus 2 strokes. That was key. So you see that the writer of the will lifted their pen multiple times, versus in the other 2, Lou Donaldson never lifted his pen in the Lou or Donaldson, or at least rarely did.
All right. Was there anything else you took into account when coming to a conclusion in this case?
Yes, so not only did I look at the signatures, but I also took into account the wording of the will as well as the individuals that had signed as witnesses to the will.
Okay, I'm going to stop the share here. Now, before we go into that information that you just told us about, do experts in your field reasonably rely on information that you just mentioned in coming to a conclusion about the authenticity of a signature or a forgery?
Absolutely. I mean, we have to. You have to take into account the context of the situation to determine whether, somebody would have a motive to forge the document, for example.
All right. The first thing you mentioned was a second witness to the will. What was it about that second witness to the will that alerted you that this might not be an authentic will?
Yeah, so the 2 witnesses on the will were a Samantha Lane and a Karen Baja, who I guess we're all familiar with at this point. But specifically as to Samantha Lane, she actually called me and contacted me to recant. She actually told me that she never saw Mr. Donaldson sign the will.
Objection, Your Honor, to hearsay.
Your Honor, if I may be heard. This is an exception to hearsay. I apologize, Your Honor. This is an exception to hearsay under 801 D1A, pardon me, as an inconsistent statement. Now, Ms. Lane, as Ms. Pride has just explained, signed the will and attested that she did see Lou Donaldson sign it. So her calling thereafter is an inconsistent statement with that signature, and therefore it's an exception under hearsay under 801.
Any reply?
Your Honor, I believe the exclusion that opposing counsel is relying on applies to when a declarant testifies to a statement and is subject to cross-examination about that prior statement. Samantha Lane is not testifying about her prior statement in court today, and that exclusion does not apply in this case because Samantha Lane is not subject to cross-examination about that prior statement.
And final response from the plaintiff.
Your Honor, I have a good faith basis to believe that Chris Renard, the defense's expert, actually disregards this exact statement. And therefore, it's important for the jury to be able to hear from Ms. Pride as to what Ms. Lane was going through her mind and the sort of information that was going through her mind. And Your Honor, I believe that this is also under 703 and subject to that reverse 403 standard. It's important for the jury to be able to hear this testimony to judge the credibility of this witness. And it's highly probative as to whether or not this will is authentic. And therefore, even if used for its non-hearsay purpose, should be understood and spoken to the jury.
All right. I'm going to allow this statement under the 703 standard, not for the truth of what it asserts under an exception to hearsay. So I will constructively give it a limited instruction to the jury as to what purpose they may consider this for. It's to evaluate the conclusion of this witness and not for it actually being the truth of what is asserted.
Yes, Your Honor. Now I want to go ahead and talk about the wording of the will that you just mentioned. What was it about the wording of the will that made you question the authenticity of it?
So it was one particular phrase that stood out to me. The will specifically said that Miss Baja would inherit Mr. Donaldson's estate if he died or, quote, disappeared. And that really stood out to me.
Have you ever seen that phrase die or disappear in any of the wills that you've examined over the years, over your career?
Never, not once.
What was it about that phrase that made you question the authenticity of this will?
I mean, obviously it was strange that it was there in the first place, but even more striking in this case, Mr. Donaldson did, in fact, disappear. So that definitely made me question the validity and the authenticity of the will.
Now, Ms. Pride, did you come to a conclusion to a reasonable degree of certainty based on your education, training, and experience about the authenticity of Lou Donaldson's signature and the authenticity of the June 12th June 14th, 2012 will, excuse me.
Yes, I did.
And what was that conclusion?
I believe that the signature was forged or copied by somebody else.
Thank you, Ms. Bride. Your Honor, I have no further questions at this time.
Thank you, counsel. Any cross-examination?
Yes, Your Honor. Ms. Pride, I want to start by talking a little bit more about your investigation into Lou Donaldson's disappearance. Now, you started by going to the Pioneer County Sheriff's Office, right?
Yeah, I believe that's how I started the process.
They still consider the case active.
They do.
You weren't able to get much information from the county's office, were you?
No, unfortunately not.
So you proceeded to conduct your own investigation.
I mean, I guess it depends on what kind of investigation you're talking about. I guess I looked into it for the purposes of determining if the will was forged or not.
But that's not all you looked into, is it, Ms. Pride?
Well, I mean, obviously there were relevant things to look into for that end.
Ms. Pride, you were hired 5 years after the events of all of this happened.
That's correct.
You worked as a detective for 16 years prior to starting your company.
That's correct.
You were assigned to the economic crime unit for 8 of those 16 years, weren't you?
I believe it was 6 years, but yes.
And you've investigated every type of case in your tenure as a detective.
I mean, I don't recall all of the different types of cases, but I definitely focused on forgeries and handwritings.
But you've investigated everything from economic crimes all the way to murder, haven't you, Ms. Pride?
You know, I honestly don't know the specifics. I know I've investigated economic crimes, but I don't totally recall the rest of the specifics of my investigations.
You have investigated murders, right, Ms. Pride?
I don't recall if I've investigated murders in particular. I just know that I was a detective for 16 years, and then I was in the economic crimes unit for 6 years investigating white-collar crimes.
Ms. Pride, when you were hired as a private investigator, you prepared a report, didn't you?
I did.
In that report, you included all of your relevant background.
Yes, I always try to.
You knew that you had a duty to update that report if anything about that had changed prior to trial today.
I mean, I guess it depends on what specifically you're talking about updating, but yes, I do have a duty generally to update if something, would change my conclusion.
Your Honor, permission for my co-counsel to publish the report of Ms. Pride.
Yes, for impeachment purposes.
Yes, Your Honor.
Okay, you may.
Now, Ms. Pride, is this a copy of your report?
Yes, that is.
This seems to be a fair and accurate copy of your report.
Yes, it is.
If we scroll down to page 19 of this report, that's your signature on the bottom of this report.
It is.
And this report has everything about your relevant background that you used for this case.
The background that I used for the case are about my my personal experience.
This has everything about your experience as a detective.
I mean, it has everything that I thought was relevant here. I also believe I have a resume, but yes, everything that was relevant here. Yes.
Ms. Pride, could you please read silently on this first page at the bottom of the first paragraph while I read out loud? In my 16 years as a detective, I investigated every type of case, from economic crime to murder.
Yeah,
did I read that correctly?
You did. Thank you for refreshing my memory. I couldn't totally recall.
Ms. Pride, you couldn't find Lou Donaldson's body in the course of your investigation.
No, I personally did not locate his body. That's correct.
You couldn't find any DNA evidence in the course of your investigation?
No, I was pretty focused on the will. I did not.
You didn't even interview Karen Baja in the course of your investigation.
I read her statement, but no, I didn't, sit down with her one-on-one.
So that's a no to my question. You did not interview Karen Baja in the course of your investigation.
Not one-on-one in person, no.
I want to talk a little bit about the evidence you did collect. You found evidence that a restraining order was filed.
Yes, I did.
But you couldn't investigate any details about Lou and Karen's marriage prior to the filing of that restraining order.
So I couldn't, your question is whether I could or could not investigate
You
everything
couldn't
prior to that?
investigate.
I didn't personally look into that, if that's your question, no.
You don't even know what could have led to the filing of the TRO.
I mean, I didn't look into that, if that's your question, no.
Now I want to move on to the will, which was the focus of a lot of your testimony on direct. Do you believe it was forged?
Yes, I do.
You did this by comparing the signature on the will to your known samples?
That's correct.
According to you, a signature that looks different from a known sample could be a forgery.
I mean, yeah, that's a possibility.
It can look different due to what you call quivering lines.
Yep,
It can look different due to strange marks associated with the signature.
it can, yes.
Ms. Pride, a signature that's 100% identical to a known sample could also be a forgery.
Yes,
In fact, a signature that's 100% identical is almost guaranteed to be a forgery.
it can be, yeah, that's correct.
I want to talk a little bit about some of the circumstances that you had mentioned out on direct. You talked about finding the language, if I die or disappear, to be suspicious.
Yes, I did.
Ms. Pride, you testified that you've investigated hundreds of wills.
That's correct.
Some of those wills turned out to be forgeries.
Yes, presumably in my years, yes, some have been forgeries and some haven't.
And none of the ones that weren't forgeries had this language.
So none of the ones that were not forgeries had this language. Is that your question?
Ms. Pride, none of the ones that turned out to be genuine had any language about disappearing.
That's correct. None of them at all had any language about disappearing.
And so none of the ones that were forged had any language about disappearing.
Correct. None of them did.
You can't even speak to why such language might be included in a will.
I mean, yeah, I didn't write it, so I don't know.
I just want to go into your conclusions. You concluded that the will was fraudulent, that Ms. Baja was responsible for Lou Donaldson's death, correct?
Yes, I did.
You didn't consider any other suspects in the course of your investigation?
I mean, I guess I looked into it and determined Miss Baja didn't. Could you rephrase your question? Sorry.
You didn't look into any other suspects, Ms. Pride. Ms. Baja was the only suspect you looked into.
Yes, based on my report, that is correct.
You couldn't tie Ms. Baja to Lou Donaldson's location the night of the disappearance.
Like with GPS? No.
You couldn't even find any hard evidence that Lou Donaldson is dead.
That's correct.
No further questions, Your Honor.
Thank you, counsel. And your redirect.
No, Your Honor, at this time, may this witness be excused.
Yes.
And at this point, the
Any
plaintiff
further
rests our.
witnesses? Okay.
I apologize.
Sorry.
Yeah, at this time,
You rest your case?
Yes, Your Honor.
All right. Are there any motions by the plaintiff at this time?
No, Your Honor, we have no motions at this time. We're ready to proceed to defense case in chief.
Any motions by the defense at this time?
Your Honor, the defense has no motions at this time and is ready to proceed into our case in chief.
I appreciate both sides ready to proceed, but we're going to take a quick break. I have it as 10:27 Mountain Time. So we will start the defense's case in chief at 10:35 Mountain Time. So that should give you about an 8-minute break. And we'll see everyone then.
Thank you, Your Honor.
Thank you, Your Honor.
Looks like we're missing just one. All right, there we got everyone. If you guys saw in the chat, as far as the time check, plaintiffs have used 34 minutes, defense has used 22 minutes. And with that, we will proceed to the defense's case in chief. Defense, you may call your first witness.
Thank you, Your Honor. The defense calls Karen Baja. I'd like to begin by letting you tell the jury a bit about yourself. Could you please introduce yourself to the jury?
Yes, my name is Karen Baja.
And what do you do for work, Miss Baja?
I run Wild Wildlife. It's a big cat sanctuary where we care for these majestic creatures, lions, tigers, leopards.
And how are you connected to the plaintiff?
He's my stepson.
I'd like to start off by talking to you about the relationship you had with Lou Donaldson and his family. How did you and Mr. Donaldson meet?
It's a really great story. I was hitchhiking and Lou just showed up like my knight in shining armor. The rest was history. He was my Prince Charming.
And how did the plaintiff treat your relationship with Mr. Donaldson?
Cam never accepted me. Despite my best efforts, he never liked me.
What, if anything, did you do that might have contributed to a poor relationship with your stepson?
I didn't do anything. As I said, I always tried, but I came from humble beginnings, and Cam just always was suspicious. He thought I was with Lou for the money, and though I tried.
Speculation as to
Bonds
Cam
counsel speculation.
thought.
Excuse me, could you repeat yourself, Your Honor?
Do you have a response to the speculation as to the plaintiff's thoughts about Ms. Baja?
I'll rephrase, Your Honor.
Right. Thank you.
Ms. Baja, what kind of background did you come from?
As I said, I came from a fairly poor upbringing.
Was your husband's family aware of that background?
Yes, and
Objection, speculation.
Overruled.
May I repeat the question, Your Honor?
Yes.
Was your husband's family aware of your background?
yes, and they constantly held it over my head.
Other than the issues that you had with the plaintiff, were there any other issues with your relationship with your husband?
Yes, as the years went on, Lou's off the books lifestyle really put a strain on our marriage. It was difficult with all of the secrets.
I want to unpack that and make sure the jury understands. What do you mean exactly by off the books?
Lou was a private man, and he was known to just keep things from people. He would pick up and go on trips, and he wouldn't really tell anyone what he was up to, and it strained our marriage.
I'd like to talk a little bit more about that strain that came from your husband's off-the-book lifestyle. Did you ever bring up your concerns to him?
I did. We were fighting a lot. Lou brought up the subject of divorce, and at one point he even sought a restraining order, but the court dismissed it. We were working through it.
Were you able ever to fully work through those tensions?
We were working on it. Lou had a mistress, which was tough, but we were doing our best until he fell off the grid.
Do you know anything about that mistress?
No, only that she lived in Costa Rica.
To your knowledge, did Mr. Donaldson visit her in Costa Rica?
Yeah, he would take off on these flights to Costa Rica all the time.
Did he purchase plane tickets for those flights?
Oh no, he flew his own planes. It was a hobby of his. So yeah, he would take his own planes.
Are there any records of those flights?
No, Lou's license was suspended. So, he would often fly without a flight plan, just coming and going, as I said.
Objection, lack of foundation and speculation as to a lack of flight plan and a lack of license.
I believe this has already been testified to at the trial, I think by Cam Donaldson. So I'm going to overrule the.
What kind of plane did your husband fly when he was taking these unrecorded flights?
I couldn't even tell you. He was buying and selling planes all the time. So I don't know which specific one. They were always kind of changing.
So how did you know then if there was no flight plan when he was flying to Costa Rica?
Often I wouldn't. He would just come and go, business trips, personal trips. So it was really hard to keep track.
I'd like now, and I know this is difficult for you, but I'd like to turn now to that last time, the night Mr. Donaldson dropped off the grid and disappeared. Where were you in the early morning hours of August 18th, 2012, starting around 1 a.m?
I was at home.
And what were you doing at home that morning?
One of our tigers had just given birth to a litter of brand new baby cubs, but she'd rejected them. So I took it upon myself to care for these little babies, and they take a lot of work.
Did you stay at home with them that whole morning?
No. In the middle of the night, around 3 a.m., I realized that we'd run out of formula. And so I had to go get some more. So I hopped in my car and ran to the grocery store to get them the formula they needed.
What happened after you got to the store and got the formula?
Well, I was on my way back and my car broke down. And I left my house in such a hurry to get these little guys their formula that I'd forgotten my phone. But fortunately, I was able to borrow a nice stranger's phone, and I called my brother to come pick me up.
What time did you call your brother?
This was around 3 a.m.
Miss Baja, why didn't you call your husband for a ride?
I had no idea where Lou was. It was 3 a.m. I was on the side of the road, and my brother, I knew he was working nearby that evening, so it just made way more sense.
After your brother picked you up, what happened next?
Well, Carl arrived and he checked out my car to see if he could get it up and running, but he couldn't. So he just dropped me off at my house, and I was able to get back to the Cubs.
What time did you get back to those Cubs at home?
That would have been around 3:45 or 4.
And what happened when he dropped you off?
I just went straight to the Cubs and got right back to work. And, I was able to give them their formula and they pulled through. They're doing wonderfully.
What did you do the rest of that day?
I was just taking care of these Cubs. As I said, it's labor intensive.
Did you see your husband at all that day?
No, I didn't.
And what did you do the next morning?
The next morning, I went to the wildlife office. I felt like I needed to be there. I had every right to be there, and I wanted to make sure I could open up.
I want to talk to you now just a bit about what may have happened to Mr. Donaldson when he dropped off the grid. Did you have Lou Donaldson killed?
No, it's an absurd allegation.
Do you know what happened to your husband?
I don't. For all I know, he's off in Costa Rica. He may have had an accident on his way. I just don't know, which is the most painful part of all of this. And frankly, Cam's just made it a lot worse.
Miss Baja, your answer begs the question. If you don't know what happened to your husband and think there's a chance he still might be alive, why did you petition to have him declared legally dead?
As the days turned into weeks, turned into months, turned into years, I just needed to have that closure for myself. I needed to put this tragedy behind me. It was all I could do to just try to get closure and move on.
Ms. Baja, have you seen a copy of your husband's will?
Yes, I have.
And today you heard the plaintiff's expert testimony discussing certain language.
Yes.
If I should die or disappear.
Yeah, that's what Lou's will said.
Based on your relationship that you shared with your husband, why did the will contain that language?
Objection, lack of foundation and speculation. Your Honor, if I may be heard.
I don't think you need to be. I don't think there's been foundation laid as to how she knows that yet. So I will sustain the objection, but I will allow you to try to lay some foundation, Mr. Fairbanks.
Yes, Your Honor. Could you describe the relationship you had with your husband?
Yeah, I mean, it was like any marriage. We had our ups and downs, but it started off really wonderfully, and we ran this incredible special business together, and we worked closely with Wild Wildlife. Despite any rough patches we had, we still ran the business together. Despite
those rough patches, how did Mr. Donaldson feel about you?
I think he always
Objection,
loved me.
speculation. Your Honor, if I may be heard.
Go ahead.
I have a good faith basis to believe that opposing counsel is attempting to lay foundation that because Ms. Baja, her husband loved her, that he therefore put the phrase die or disappear into his will for a particular reason. That would be speculative, as it would go into the mindset of Lou Donaldson when he purportedly wrote a will. And therefore, we ask that this testimony be struck. Furthermore, this exact answer as to what Lou Donaldson felt about Ms. Baja is speculation.
Any response, Mr. Fairbanks?
Yes, Your Honor. I'm asking a wife what she thought her husband felt for her. Under 701, this is an opinion rationally based on the variety of perceptions that she had over the course of their marriage.
Your Honor, if I may be heard.
So, no, I'm ready to make my ruling on that. So I think there are two separate issues that are kind of being joined together here, and I guess the direction this questioning is supposed to go. As far as the defendant giving her lay opinion about how she believes her husband felt about her from everything that went on in the relationship, I'm going to allow her to testify to that. As far as any testimony about why the will said what it said, unless there is some sort of foundation where her husband told her, I'm putting this in the will because of this, I'm not going to allow that opinion. Certainly on closing argument, counsel, you're allowed to draw those inferences yourself for the jury.
Yes, Your Honor. Thank you. So, Ms. Baja, how did your husband feel about you?
He always wanted to make sure that I and the cats were taken care of. Despite his eccentricities and his comings and goings and his lifestyle, I know in my heart of hearts that he wanted me to be taken care of.
And based on Lou Donaldson's will, did you feel taken care of?
I did, but if I could trade it all, the life insurance and even the cats, just to get Lou back, I would.
No more questions, Your Honor.
Thank you, counsel. And cross-examination.
Yes, Your Honor, may I proceed? Ms. Baja, between the time of August 17th to August 18th of 2012, only you and your brother can account for your whereabouts. Isn't that right?
Yeah, those tiger cubs can't talk.
And after your husband disappeared, it's your contention he left everything to you in a will, right?
I mean, that's what the will says. It's not my contention.
And you'd agree with me that will was signed 2 days after Lou Donaldson filed for a restraining order against you. Isn't that right?
Yes, that's right.
So let's talk a little bit about your marriage. Like you told us on direct examination, 2012, you were having a lot of problems, right?
It was a difficult year.
You and Lou were fighting a lot, right?
Yeah.
Lou told you he wanted a divorce. Isn't that right? He did. And he filed for a restraining order, didn't he?
Yes, but as I said, the court dismissed it and we were working through it.
You'd say you'd never threaten to harm your husband, would you?
You know, our fights would get pretty colorful. So, you know.
I'm going to take you back to my question. You'd say you'd never threaten to harm your husband, right?
Never seriously, no.
Ms. Baja, I'm going to direct your attention to page 55 of the case materials, date stamp number ending in 0016. Let me know when you get there. I'm there. This is that TRO that Lou filed against you, right?
Looks like it.
It's his signature, isn't it?
Yep.
And it's dated June 12th, 2012, right?
Yes, that's correct.
Your Honor, motion to enter is plaintiff's two, excuse me.
Any objection?
Yes, Your Honor, if I may be heard.
Go ahead.
As to the evidence itself, I have no issue with the TRO coming in as long as that first line, Karen Baja, defendant has threatened to kill me, is redacted as ruled pre-trial.
Yep. We will constructively redact the entirety of sentence number 1.
Thank you, Your
but
Honor.
apart from that, I will admit.
Motion
you may
to
publish
publish.
to the jury.
Thank you. Ms. Kovach, can you put that on screen for me? Ms. Baja, this says I'm seeking a divorce from Karen Baja. That's what it says, right?
Yes, as I just said, Lou had talked about divorce.
It says I don't feel safe around Karen Baja, doesn't it?
It's what he wrote.
And it's dated June 12th of 2012, right?
Yes.
All right, Ms. Kovach, if you can take this down. I want to talk to you about what happened just 2 days later. Now, it's your contention that your husband, of his own volition, signed a will on June 14th of 2012. Isn't that right?
That's what the will says. Yes.
I'm going to direct your attention to page 53 of the case materials, date stamp number ending in 0014. Ms. Baja, why don't you let me know when you get there?
In there.
That's that will, right?
It is.
True and accurate copy, isn't it, Ms. Baja?
Yep.
Your Honor, motion to enter is plaintiff's 3.
Any objection?
No objections, Your Honor.
It's admitted.
Ms.
And
Kovach.
you may publish.
Thank you, Your Honor. Ms. Kovach, can you go ahead and put that on screen? I can go ahead and do that. This is that will, isn't it, Ms. Baja?
Yes, it is.
And it's signed June 14th of 2012, right?
Yep, right there.
So it's your testimony that 48 hours after, in a court filed document, your husband said he wanted a divorce, that he made you the executor and a second witness to his will. Am I getting that right?
Yeah, as I said, 2012 was a wild year and we had our ups and our downs, but our marriage was our own and we had been working through our problems, and this is what Lou wanted, as is evidenced by this document.
Objection, Your Honor. Motion to strike the latter portion of the testimony as of what we wanted, speculative, and in that it's specifically regarding Lou Donaldson.
I'm not going to strike it, but I will allow you to certainly inquire into that, whether she actually heard those statements from the defendant or that's just her impression.
So let's be clear. It's your impression that's what he wanted you to do, or what he wanted from this will, right?
His signature at the bottom of the will that describes his intentions, yes, I inferred that that's what he wanted.
He never told you directly that you can tell us on the stand that he wanted to give you everything, right? He didn't say those words.
No, he just wrote it in as well.
And let's go back to this, Will. It's your contention that 48 hours after he filed for a restraining order against you, that he made you the sole beneficiary of all of his real and personal property here at the top, right?
Yep, that's right.
And he did all of this whether he would die or disappear. Is that right?
Yeah,
On August 18th, 2012, your husband did disappear, didn't he?
he did.
And you know that if it was found that you had murdered your husband, well, you certainly wouldn't get all his real and personal property, would you?
I would hope not. My God.
So you had to wait 5 years for him to disappear for long enough to get all of his real and personal property, right?
Objection, Your Honor, calls for a legal conclusion.
Your
Response?
Honor, if I may be heard.
Go ahead.
Direct examination, Ms. Baja told the members of the jury that she waited 5 years to declare him legally dead so that she could get all the real and personal property. She gave it as a reason of closure. We're cross-examining to inquire about that.
I'm going to overrule the objection. To the extent this witness knows what she needed to do or why she waited that long, she can certainly testify to her understanding of what the law is. Obviously, she's not going to be able to testify to what the law is or is not in actuality.
Yes, Your Honor. Ms. Baja, you waited 5 years to have your husband declared legally dead, true?
Yes.
And then after you had him declared legally dead, you got all his real and personal property, right?
Yeah, I just needed to move on, and that's what the will said, and I needed the closure.
And after 5 years, you also filed for that life insurance policy, right?
Yeah.
So let's talk a little bit about the night of August 18th of 2012 when your husband disappeared. Now, you stated on direct examination that you were alone that night, right?
I'm sorry, on which night?
August 18th of 2012, around the time your husband went missing, you said you were alone with those tiger cubs?
Yeah, that's right.
And you were home alone with them, is that right?
I think so. I didn't know where Lou was.
Well, you don't have any photos of those tiger cubs with a timestamp showing you were alone with them, do you?
No, my attention was on taking care of them.
So certainly no video recording, right?
No.
Now, you and your husband have been taking care of tiger cubs since the beginning of your marriage, right?
Yes, that's right. It's what brought us together.
And you've taken care of cubs in the past, right?
Oh yeah, a lot.
So you know that when a tiger mom rejects her cubs, they might need things like milk and formula, right?
Yeah.
So it's potentially a big problem to run out of milk and formula, right?
Definitely, counsel.
So it's your contention that around 3 a.m. on August 18th, 2012, right around the time that your husband went missing, you just realized that you were out of milk and formula despite doing this for years. Am I getting that right?
Yeah, it's a pretty hectic undertaking. And they eat a lot. And yeah, so it just happens.
Just happens. Okay. And you just happened to go to the grocery store. That's what you said, right?
Yeah, I had to get the formula.
You don't have any receipt from the grocery store showing you bought milk and formula, do you?
Don't.
How about a credit card bill or a canceled check?
No.
Can you tell us who the checker was who checked you out for milk and formula at 3 a.m. on August 18th of 2012?
I can't.
And then you said when you left the grocery store, your car broke down, right?
It did.
And you also just happened to not have your cell phone. That's what you said?
Yeah, it was a really hectic night.
And so you flagged somebody down to use their phone, right?
Yes.
You can't tell us who you flagged down, do you?
No.
How? And since you didn't have your phone, there's certainly no phone calls or text messages from your phone around that time, right?
That's right.
And then you said 3 a.m., stranded at a grocery store, car broken down. You call your brother, is that right?
Yeah, he's a sheriff's deputy, and I knew he was working that night. So yeah, it just made the most sense.
You know that Lou had a cell phone, right?
Yeah, he did.
You knew his phone number, right?
Yeah, of course.
And you call your brother instead. You're pretty close with your brother, aren't you?
Yeah.
And he came to check your car, like you said, on direct examination?
Yes, that's right.
You don't have any receipt from an auto shop showing what was wrong with your car, do you?
No, I don't.
Didn't call a tow truck, did you?
No.
So no tow truck driver could put you there, right?
Nope.
And then you said your brother drove you home in his deputy car, right?
Yes.
And since it's just the two of you in the car, the only two people who can account for your whereabouts at that point are you and your brother, right?
Yes, that's right.
Let's talk a little bit about your cats. They eat a lot of fresh ground meat, right?
They do.
And you grind that meat on site in an industrial grade meat grinder. Isn't that right?
Yes, there is a meat grinder on property, but multiple employees use it. It's not just me.
I'm going to take you back to my question. You grind that meat in an industrial grade meat grinder, right?
Yep.
That meat grinder can fit a human body, can't it?
Objection, Your Honor. Lack of personal knowledge, speculation.
Your Honor, if I may be heard.
No need. Overruled.
I'm going to take you back to my question, Ms. Baja. That meat grinder can fit a human body. Isn't that right?
I mean, theoretically, yes, it's big enough.
And it takes two people to operate, right?
It does.
You and your brother were together on August 18th of 2012, like we just talked about, right?
Yes, we were.
Now you say that meat grinder got checked for evidence, right?
That's right.
And that there was no evidence on it, right?
Correct. They found no evidence.
Remind me, your brother, he's a sheriff's deputy, right?
Yes.
You were here during the testimony of Miss Pride, weren't you?
I was.
You heard Miss Pride tell us that the investigating agency was the sheriff's department, right?
Yeah, they investigate crimes in the area.
Thank you, Ms. Baja. I have no further questions at this time.
Thank you, counsel. Any redirect examination?
Yes, Your Honor. How often do you need to feed the animals at the reserve?
Oh, pretty frequently. They eat a lot of meat.
So do you have to feed them daily?
Oh, yeah.
Does that go for tiger cubs as well?
Yes, but they eat formula when they're young and then graduate to meat.
So on those daily feedings, do you regularly take photos of the animals while you feed them?
No.
When you go shopping, do you regularly keep all your receipts?
No, I'm kind of a scatterbrain.
Do you regularly remember the name of the employee at the checkout?
I do not.
Last question, Ms. Baja. On the night of your husband's alleged disappearance, when you were trying to get home, did you think Lou would have picked up if you called?
No, as I said, I had no idea where he was and I needed to get home to the Cubs. So I was not going to waste time trying to track down Lou.
No more questions, Your Honor.
Thank you, counsel. This witness may be excused. And defense, you may call your next witness.
Yes, Your Honor. At this time, the defense calls Chris Renard to the stand. Could you please introduce yourself to the court?
Yes, my name is Chris Renard.
Ms. Renard, what do you do for a living?
I'm an investigator and forensic document investigator.
What was your education prior to working?
Well, I received a BA in criminology from Summit College in 1996. And then I went on to graduate from the Statesville Police Academy in 1997.
Did you actually work as a police officer after graduating from the academy?
Sort of. I didn't work as a police officer like you would typically think, like out on the street, stopping people, that sort of thing. I actually ended up working for the state's crime lab as a forensic document examiner for 3 years.
Does that kind of work require any additional training?
Yeah, so it requires certification. And so I was certified by the Board of Forensic Document Examiners.
Ms. Renard, you mentioned that as well as being a forensic document examiner, you're also an investigator. What do you investigate?
Well, I currently work for the Summit Life Insurance Company, and in my capacity working there, I investigate the possibility of fraud claims on life insurance policies.
How long have you worked for the Summit Life Insurance Company?
I believe about 20 years now.
Does that fraud investigation work you do require any additional training?
Yes, so I have to be certified, and so I'm certified by the Association of Certified Fraud Specialists.
Do you have to keep up to date on all of this training?
Yes, so I attend annual training workshops and as well as doing continuing education programs for both forensic examination as well as that fraud investigation.
Ms. Renard, have you testified in court about this forensic document examination and fraud investigation work in the past?
Yes, I've testified as an expert 25 times. One time was for the prosecution, and then I've testified 24 times on behalf of our insurance company.
Were you employed by Ms. Baja in today's case?
No, I was not.
So were you asked to investigate this case?
I was, yes.
Who asked you to investigate it?
So my employer, specifically the CEO of Summit Life Insurance.
What did you review in the course of your investigation?
So I looked at Mr. Lou Donaldson's last will and testament, Mr. Donaldson's life insurance policy with us that contained a known sample of his signature. I also looked at Mr. Donaldson's driver's license, which provided another sample of his signature. I did interviews with Samantha Lane as well as Karen Bagia, and then I spoke to a contact in the sheriff's department about their investigation into Mr. Donaldson's disappearance.
Is this the kind of evidence that an investigator such as yourself would rely on in an investigation like this?
It is.
Based on your experience, is this evidence sufficient to conclude an investigation?
It is.
Yep. Could you tell us a little bit about the methods that you used while investigating?
Of course. So especially with that forensic document examination, the first thing that I do is I look at the signatures that is on the last will and testament, as well as the provided samples for that person. So when you look at those signatures, you look at a number of different characteristics for the letters. You look at things like similarities and differences in loops, stroke and stroke direction, curves of letters, the legibility of the signatures, angles of the letters, any embellishment that's included to the signatures, and then which letters are capitalized in those signatures. I also was able, on the other hand, in the investigation side, to conduct personal interviews to try and verify the authenticity of that will.
Ms. Renard, are these methods standard methods in the field that you investigate in?
They are.
Were you able to reliably apply them to the facts and data that you reviewed in preparation for this case?
I was.
Your Honor, at this time, the defense tenders Ms. Chris Renard as an expert in fraud insurance investigation, as well as in forensic document examination.
Any objection or voir dire?
No objection, Your Honor.
She's admitted.
Mr. Renard, I want to get into some of the specific work that you did in preparation for this case. You mentioned your CEO asked you to investigate. What exactly did he want you to investigate?
Well, I was asked to determine whether or not Summit Life Insurance, whether we were required to pay out Mr. Donaldson's $5 million insurance policy to Ms. Bagia.
Why were you asked to investigate that?
Well, my CEO wanted me to look into whether or not Ms. Bagia was responsible for the death of Mr. Donaldson and whether or not that will was forged. If either of those things had been true, we wouldn't have been required to pay out that $5 million policy.
I want to take those one at a time, Ms. Renard. Your Honor, permission to have my co-counsel publish a demonstrative that will be created throughout the course of this witness's testimony.
That's fine.
Ms. Renard, I want to start with the first part of your investigation, which is whether or not Karen Baja had anything to do with Lou Donaldson's disappearance. Do you think Karen Baja killed her husband?
I do not.
And why don't you think that?
Well, first and foremost, the sheriff's office has never charged or even listed Ms. Bagia as a suspect.
Objection, Your Honor.
I believe this gets back to the motion limine, counsel.
Yes, it does.
So if you can lay some foundation as to if this is the type of information that she would rely on in coming to this expert opinion in the normal course, and then we will address whether or not it comes in, okay?
Yes, Your Honor. Ms. Renard, a little bit earlier, we talked about some of the stuff that you had relied on. Did you rely on some of the information you were able to get from the sheriff's office?
I was, yes.
Were you able to get any of this information publicly?
Yes.
Were you able to get some of this information privately?
Yes.
And is reliance on both of those categories standard for your investigations?
Yes.
Ms. Renard, why is it that you think Karen Baja didn't kill her husband?
Well, as I was saying, first and foremost,
Your Honor, first of all, we don't believe that the foundation has been properly laid here. And second, in terms of the information she gained publicly specifically.
Okay, so as far as counsel being allowed to go into this area, I'm going to allow that. And I'm going to give the same type of constructive limited instruction that I gave with the plaintiff's expert, that this is under 703 only, and it is only to help the jury understand how this witness came to this conclusion and to properly evaluate whether to believe this witness's conclusion or not for the truth of what it asserts. Certainly, counsel, on cross-examination, you will have legal way under 705 to probe whatever she knows or doesn't know and the reliability of that information.
Ms. Renard, why do you think Ms. Baja did not kill her husband?
first and foremost, the sheriff's office has never charged or even listed Ms. Baja as a suspect in Mr. Donaldson's disappearance. That's public knowledge at this point.
Now, were you able to get any other information from the sheriff's office?
I was not, because their investigation is still ongoing. It's still classified as active. They've been very reluctant to release big amounts of information about the investigation.
So could you get any other evidence to help you support this conclusion?
Yes, so I have a contact at the sheriff's office, and I was able to learn two things from that contact.
What was the first thing that you learned, Ms. Renard?
The first thing was that,
Your Honor, lack of foundation for the conversations with this contact.
I'm going to make my same ruling on 703. I think, counsel, this is ripe for cross-examination about the reliability of this source that at this point is unknown, other than it's just a contact. But you may continue, counsel.
So, Ms. Renard, what was the first thing that you learned from that contact?
So the first thing that I learned was that Ms. Baja had provided an alibi for at least some of the time that covered when Mr. Donaldson went missing.
What was the second thing that you were able to learn?
The second thing I was able to learn is that the sheriff's investigation includes no suspect of foul play, and that's just based on what they've been able to learn in the course of their investigation.
I want to move on to the second part of your investigation about the will. Do you think Lou Donaldson's signature on that will is genuine?
I do.
Why do you think that, Ms. Renard?
Well, the signatures in the samples provided and the signature on the last will and testament were sufficiently close enough that it could have been a genuine signature. Additionally, the signatures in the samples and in the last will and testament were not different enough for me to conclude that it was in fact a forgery.
Ms. Renard, could you remind us what you look at when you're comparing two signatures?
Of course, so you're looking at the characteristics of the letters in the signatures. You look at things like loops, stroke and stroke direction, curves, legibility, angles, embellishment, and capitalization, among a number of other things.
What are some things that can cause any given signature to appear different from a previous one?
There are a number of things. A person's difference in age between when they signed one thing and another, changes in their health, the care when signing a document, the writing instrument used, the surface that the signing has been done on, and even something as simple as the person who is doing the signing kind of wanting to do something else, kind of hurrying through that signature. Those are all possibilities of why a signature may look somewhat different to another in addition to a forgery.
Were any of those other factors present in the case of the signature on this will?
Just based on what I had in my investigation, I'm not sure. I really did not have a way of checking to see if any of those differences were present.
Did you rely on any other evidence when trying to figure out whether or not this will was an authentic will?
Yes, I conducted 2 interviews, the 2 interviews of the people who witnessed the signing of the will to verify the authenticity.
Who was the first witness that you contacted, Ms. Renard?
The first witness that I contacted was Samantha Lane.
Did Ms. Lane verify her signature on that will?
She did.
Did you hear from Ms. Lane again at any point?
I did not.
Did you ever receive anything from Ms. Lane?
I received something that was signed by a person who was calling themselves Miss Lane, but I could never verify who it actually came from.
Ms. Renard, did you ever analyze the signature on that document to determine its authenticity?
I wouldn't say I did a complete investigation, but I did not believe that that person who sent it was in fact Samantha Lane.
Did you rely on that letter in coming to any of the conclusions that you've been testifying about?
Only in the sense that I believed it was not in fact the person they were saying they were, Samantha Lane. But other than that, I did not rely upon that in determining whether or not the signature was in fact a forgery or not.
Did its receipt change your conclusions at all?
No.
Who was the second person that you contacted, Ms. Renard?
The second witness was Miss Bagia.
And did Ms. Baja verify her signature on that will?
She did.
I want to get to the final conclusions that you gave your employer, Ms. Renard. Now, what did you conclude to your employer about the veracity of that signature and the authenticity of that will?
Well, my conclusion was that the signature appeared genuine and that it had been verified by both of the witnesses to the signing.
What did you conclude about Karen Baja's involvement in the disappearance of her husband?
I concluded that she was not involved in the disappearance of Mr. Donaldson.
So based on your investigation and based on what you were able to find for your employer, what was your final conclusion to your CEO about paying that policy?
Yes, I advised our CEO that we were in the clear to pay out that life insurance policy.
No further questions at this time, Your Honor.
Thank you, counsel. Cross-examination.
Yeah. Before I proceed, Your Honor, I would actually ask that counsel would leave up the demonstrative so that I may use it as well.
Okay.
And if possible, Your Honor, I would request remote control so that I may add to this demonstrative only in respect to what the witness says on cross.
As far as that, let me hear from defense as far as marking on this demonstrative.
Your Honor, as we constructed this demonstrative, it seems fair that opposing counsel has the opportunity to use it and cross-examine with it.
Okay.
Your Honor, just in terms of technical limitations, I believe I would need to share the document with edit access, which would involve school emails potentially. So perhaps it could be recreated as it is now. Or if anybody else has any good suggestions as to how to share that without.
So if you take this share screen off, are you able to send it to the email address of opposing counsel and then reshare it without? I'm guessing what you're getting at is if you share it live, it's going to show a law school's name.
Yes, exactly. So,
oh, sorry, it activated my Siri. Why don't you try to share it now without it being on the screen and see if that works, and we can pop it back up.
And if it's okay, I'll just make a copy. So I'm not showing the original, but it will be identical.
That's fine.
Thank you, counsel.
Mm-hmm.
And Ms. Kovacs, perhaps you can private whisper me your email address that you'd like me to share this to.
Here, thank you.
Okay, hopefully the invitation just went out. If you could just take a look and then confirm that you have edit access to the copy.
I'm still waiting, but I'll let you know as soon as I receive it.
Is the email you provided to me linked to a Gmail account?
It is.
Okay. I'll also try saving it as an independent Word document and then maybe trying to email it to you outside of Google Docs, if that's okay.
That's great.
So I just sent an independent email with a Word document that will hopefully. So it says the email, I just got a notification that the address you provided me couldn't be found.
That's odd. Oh.
I just copied and pasted what was in chat.
I believe I misspelled my own name, so I apologize for that.
Okie dokie. I sent yet again.
Thank you. Oh, I believe I've received it.
Does the Word document look like it's accurate?
Yes, thank you very much.
Perfect.
If you can hold on for just one moment, I will proceed. All right, Your Honor, may I proceed?
You may.
Ms. Renard, you inspected a copy of Lou Donaldson's will, right?
That is correct.
And that will contained the phrase, should I die or disappear, right?
Yes, that phrase was in that, and it was a bit unusual to me.
You've been with Summit Life Insurance for 20 years.
That's correct.
You've investigated hundreds of wills.
Yes.
And in those 20 years, you've never seen the phrase, should I die or disappear in any other will, have you?
Yes, and like I said, that's why it was a bit unusual for me to see that.
In fact, you said it was suspicious, right?
I believe that may have been a word I used.
Now, the will contained $5 million of Lou Donaldson's estate, right?
Yes.
And the sole beneficiary was Karen Baja.
Yes.
Cam Donaldson received no money from the will, right?
In what was provided in the will, no, the younger Mr. Donaldson was provided nothing in that will.
Thank you. Now, I want to move on to your financial investigation. You conducted a financial investigation into Lou Donaldson around the time of his disappearance, right?
I believe so, yes.
Lou had $100,000 in his bank account, right?
I believe that's the amount.
And that was his only account, right?
As far as I was aware of, yes.
Well, you conducted the investigation, right?
That is correct.
You solicited the bank statements.
Yes.
You told Summit this was his only account, right?
This is the only account that I could find, yes.
And to be clear, you told Summit that, in your opinion, it wouldn't make sense for someone to leave $100,000 in their only account if they were off somewhere on an island, right?
If that was in fact the only account, it would have been a bit unusual.
And it's the only account you found.
Again, yes.
And this was your investigation.
Yes.
And that's what you based your conclusion on.
Yes.
So did you ever conduct a financial investigation of Karen?
I don't believe so. Sorry.
So around the time of Lou's disappearance, you don't know how much Karen had in her bank account, do you?
No, that was not the focus of my investigation.
So to be clear, you don't know how much she had in her account?
No.
During your investigation, you never became aware of the talk of divorce, did you?
I don't believe so.
You never became aware of the temporary restraining order?
No.
So you weren't aware that the temporary restraining order was dated 2 days before the will, were you?
No, that was not a part of my investigation.
So you didn't know they were dated 2 days apart, did you?
Correct.
Now, I want to talk to you about who you did speak with during the course of your investigation. You spoke with Samantha Lane to verify the will, right?
That is correct.
She was a witness to the will.
Yes.
Initially, Samantha said that she did see Lou sign the will, right?
Yes, that is what she told me.
Now, I'd like to turn your attention to page 41 of the case file, if you could let me know when you see it.
Okay, I believe I'm there.
Do you recognize this?
Yes,
Is this a letter that you received during the course of your investigation?
it is.
Now, Your Honor, at this time, I move to enter this letter from Samantha Lane into evidence.
Any objection?
Yes, Your Honor, we object to this letter being admitted as hearsay. If I may proffer.
Go ahead.
On direct, the witness did testify about receiving this letter. And when I asked her about this letter, she said that she never performed a full investigation as to whether or not Samantha Lane's signature on that is authentic to the sample that she had on the will. She's incapable of authenticating that signature from that. She also testified on direct that it did not alter her conclusions. She did not rely on it in coming to any of the conclusions she testified about today. It is firmly out of the purview of 703 as a piece of evidence that was relied on to come to a conclusion that should then be disclosed to a jury.
In reply?
Your Honor, we believe that this is admissible under 705. This goes directly to the credibility of the witness and the investigation the witness conducted. We're not introducing it for the truth of the matter, but simply to show that this expert received a letter and consciously disregarded it. And we believe that goes very much to the issue at hand.
All right. As I mentioned during the direct examination, I gave some leeway to defense counsel under 703, and I will do the same under 705 for the plaintiff's counsel. So I will admit this. This plaintiff's, what's the exhibit number?
This is plaintiff 4.
Plaintiff 4 will be admitted, and you may publish to the jury.
Thank you, Your Honor. Now, Ms. Renard, if I'm going to go ahead and read this out loud, and if you could read this along silently with me. Dear Mr. Renard, I felt it was important for you to I felt it was important for you to know that I wasn't being honest when we last spoke. I was coerced into signing that will. I never saw Mr. Donaldson sign. Samantha Lane. Did I read that correctly?
You did.
Now, after you read this letter, you reached out to Miss Lane, right?
I attempted to get contact with Miss Lane.
And you failed to reach her, correct?
That's correct. I have never been able to speak with Miss Lane after our initial conversation.
So on direct, you said that you disregarded this letter, right?
Yes.
That you gave it absolutely no credence.
Exactly. Sorry.
You never reached out to the authorities to let them know that you'd been contacted by someone with knowledge of your investigation, claiming to have been coerced, did you?
No, I don't believe that was my responsibility.
So you never reached out, even though this person clearly had knowledge.
I did not believe that this person had knowledge.
Well, they knew that you had spoken to Samantha Lane, right?
I'm sorry?
This person clearly knew you had spoken to Samantha Lane, right?
I don't know if clearly is the word I would use, but they had some knowledge of it, yes.
And they knew that Samantha Lane was listed as a witness to the will, right?
Yes.
But you gave this absolutely no credence.
Yes.
So you next talked to Karen Baja, right?
That is correct. She was the other witness.
And Karen confirmed that she saw Lou sign the will, right?
Yes, Ms. Bagia did confirm.
Now, in your opinion, it is disfavored for a witness of a beneficiary of a will to also be the sole beneficiary of the will, right?
It's not what we would prefer, but things happen.
So it is disfavored, right?
Yes.
So in this particular case, it would be disfavored for the beneficiary of a $5 million will to serve as the witness to the signing of the will, right?
Yes.
And that's perhaps because a beneficiary of a will is an interested party, right?
Yeah, you could say that.
Now, I want to move along to your investigation as in terms of how you discussed things with the police. Now, you said on direct that you reached out to the police department, right?
That is correct.
And you said on direct that the investigation is still active.
Yes, it is.
So they couldn't give you their case files, right?
Yes.
Now, I would ask Ms. Izuriaga to please publish the defense's demonstrative at this time. Okay. Now, I want to talk to you a little bit more about what you did hear from the police. Now, when they wouldn't give you the file, you went to a contact of yours, right?
That is correct.
And you can't tell us who your contact is.
No, to keep that relationship kind of going in order for me to gain information that I otherwise wouldn't be able to, I have decided to not release the name of my contact.
So you've decided not to release the name of your contact?
Yes, that is what I just said.
You won't tell us if your contact even worked on Lou's investigation, will you?
Again, to preserve that relationship, no.
So did your contact ever give you any physical documents to review?
No, that would have been entirely unethical.
And your contact never gave you any of the files, not only physical documents, but any information specifically that they told you was from Lou's file?
I'm sorry, that was a bit confusing. Could you re-ask that question?
Of course. So your contact never gave you Lou's file?
Correct.
And your contact never gave you any physical documents at all?
Again, that would have been a bit unethical on his part.
So he didn't?
Correct.
So you never reviewed any of the police's files?
No.
Now, you think that perhaps Lou was in a plane crash, right?
That is one possibility, yes.
Now, you, to be clear, never investigated a plane crash, did you?
No, I did not.
You never found evidence of a plane crash.
No,
You never even confirmed that a plane was missing, did you?
no.
But it's your contention that Lou was in a plane crash.
I believe that's one of the possibilities of what could have happened.
Now, I want to get to this signature genuine part. There were differences in the signatures, right?
Yes,
And you said on direct that there are many things that can impact a signature, right?
oh yes, a good number of things can impact that.
Now, age is one of those things that can impact a signature, right?
Yes,
You relied on 2 authentic signatures.
yes,
You relied on Lou's signature from 2005,
yes,
and you relied on the DMV signature, right?
that is correct.
And the DMV signature is undated, isn't it?
I believe so.
So you never had a signature to rely on that you knew was within the last year or 2 before Lou's disappearance, did you?
That is correct. I
Now
did not have the exact date.
Right. So you relied on one signature that was 7 years before Lou disappeared and one signature of an unknown date to confirm the authenticity of a signature dated 2012, right?
Yes,
Now, as you said, there were differences in the signature on the will.
yes, as can be expected.
Your finding of authenticity as to the signature was inconclusive.
Correct.
You cannot say that the signature on the will is genuine.
I also cannot say that it is definitively a forgery.
So you would agree with me that you can't say it is definitively genuine.
Correct.
And when you told your employer to pay out the life insurance policy, you also told him that you wanted to avoid the possibility of contentious litigation, right?
Yes, if we had refused to pay out the policy despite the totality of the circumstances showing that the signature was genuine and showing that Ms. Baggia had no involvement in his disappearance, that could have come with some pretty hefty litigation.
So I'm going to bring you back to my question. You advised the company to pay out and advised them of the possibility of extended litigation, right?
Yes,
And you advised them that that litigation could be costly, right?
yes,
Now, finally, I want to ask you, you told your employer it is your opinion as an expert that it is possible someone tried to copy Lou's signature, right?
it's possible, but it was not a very significant possibility.
So to get back to my question, it is possible that someone tried to copy Lou's signature.
Yes, it's a possibility.
Thank you. No further questions.
Thank you, counsel. Any redirect examination?
No redirect, Your Honor.
All right. Ms. Renard may be excused. And defense, do you have any further witnesses or evidence that you want to present at this time?
No, Your Honor. At this time, the defense rests its case in chief and requests a brief 5 to 10 minute recess prior to the start of closing arguments.
All right. Before we do that, let's first turn to the plaintiff. Any motions from the plaintiff at this point?
No, Your Honor, we don't have any motions. We just asked for a brief time check before going into closing arguments.
Certainly. And any motions from the defense at this point?
No motions, Your Honor.
Okay. I show 11:39 Mountain Time. We will take a recess to 11:45 and we'll proceed with closing arguments. And like last time, if the timekeeper can just type in the chat the remaining time for each party. And I'll see everyone at 11:45. right, it looks like we're missing one, Ms. Kovacs. Defense has 6 minutes in argument. I think. Can you hear me?
I'm sorry, you broke up a little bit there, Your Honor.
Okay. I'm sorry. You may proceed, plaintiff, with your closing argument.
The first time that something happens, it's happenstance. The second time that that same thing happens, just a coincidence. But the third time that something happens, that third time, well, it becomes a pattern. If Lou Donaldson had just told his daughter on a Friday that he went missing, that he'd see her next week and to come over for supper on Sunday, that could be an isolated incident. If just a few hours later, the defendant just happened to need to go out for supplies she knew she might need and had no phone, no car, and only her brother to account for her whereabouts, well, that could be an isolated incident. And if the defendant had just broken in to Wild Wildlife's office just 36 hours later to take a single object known to contain a will, and then came just 2 weeks later with a new version of a will that entitled her to everything and cut out Lou's only child, well, that alone could be an isolated incident. Or it could be a pattern orchestrated by the one person with $10 million to gain from it, the defendant. Now, today the judge is going to instruct you that in order to find for the plaintiff, you must find 4 things are true. First, that Lou Donaldson is dead. Second, that Karen Baja's intentional or reckless conduct caused his death. Third, that Cam Donaldson suffered damages, losses, or injuries. And fourth, that those damages, losses, or injuries were caused by the defendant's conduct. Now, nobody here contests that Lou Donaldson is unfortunately dead. So let's focus on those last 3. We had to prove to you those last 3 by what's called a preponderance of the evidence, which simply means more likely than not. If you think it's more likely than not that Karen Baja's intentional or reckless conduct caused Lou Donaldson's death and his son's suffering, well, then you must find for the plaintiff. So let's go through the evidence that you heard today and go through each coincidence after coincidence and call them what they really are, a pattern. Let's go all the way back to 2012. We learned today that as the months of 2012 went on, Lou Donaldson and the defendant's marriage was unraveling. There were fights, shouting matches. When Lou told the defendant he wanted a divorce, she stormed out, and you know what he told his son? If I ever go missing, tell the police to look into Karen because she will be responsible for my death. And on top of all of that, we know that Lou, he didn't feel safe, so much so that he went to the court for protection. Today, you got the opportunity to look at a temporary restraining order application that Lou filled out. He said, I don't feel safe around the defendant. I want a divorce, and think about what a temporary restraining order is asking for. If you feel uncomfortable around somebody, you might distance yourself or go to a friend's house for a weekend. But if you feel as though you're in a risk of bodily harm, and you don't feel safe around another person, well, then you go to the court and you seek protection, which is exactly what Lou Donaldson did in 2012. And we learned today that the defendant didn't stop there. We learned a lot about her alleged handling of a will in this case. We have Taylor Pride testify before you, who has years of experience of looking at wills and determining if they were forgeries. And Ms. Pride told you this was a forgery, not just because of the signature, but because of the surrounding circumstances. Ms. Pride, she came to that conclusion because she relied on the second witness to the will, Samantha Lane, who you heard a lot about in court today. Samantha Lane told Ms. Pride she never saw Lou Donaldson sign that will. She recanted. And if that weren't enough to cast aspersions on the authenticity of this will, well, Taylor Pride told you about a very specific phrase in that will: die or disappear. Not only had neither side's expert never seen that phrase in the years of experience and hundreds of wills that they have looked at in the course of their career, but members of the jury, it came true. The defendant had to tell you on the stand today when I asked her, well, if it was found out that she had murdered her husband, she certainly wouldn't get the life insurance policy, and she certainly wouldn't be entitled to his $5 million estate. But take a step back. Let's think about timing. That will is signed June 14th of 2012, just 48 hours after Lou Donaldson filed for a temporary restraining order. The defendant on the stand, she tried to say we had lots of ups and downs and this just happened to be an up. But think about what the defense is asking you to believe. They want you to believe that on a Tuesday, Lou Donaldson is in so much fear for his life and bodily safety that he files a restraining order, but by Thursday, he's so content with his wife, who he's been arguing with all year long, wants a divorce, that he decides suddenly to hand over his life's earnings. But members of the jury, coincidence after coincidence is no coincidence at all. It's a pattern, and it's a pattern that culminated in the events of August 17th to August 19th. Today, we learned about on August 17th, Lou Donaldson said goodbye to his son for the weekend, saying, I'll see you next week, unless you want to come over for supper. And then Cam never heard from his father ever again. You know who he did hear from? Just 36 hours later? The defendant, breaking into an office that she says she's purportedly the owner of, to take a single object that no one has ever seen ever again. She tried to tell you on the stands, well, I'm an owner, I'm allowed to do what I want. But members of the jury, if you're an owner of an office, why break into it? Why cut a padlock? Why take a single object at 6 a.m., setting off an alarm and having the police come over if you have a key to the building? The defense would also tell you, well, we don't know if that lockbox had a will in it. We don't even know if that will existed, but the defense would also tell you it's just a coincidence that 2 weeks after that occurred, the defendant came with a new will. They tell you it's a second coincidence that that new will entitled her to the entirety of her husband's estate. And they tell you it's a third and final coincidence that that will inexplicably cut out his only child with absolutely no warning and completely out of the blue. But members of the jury, coincidence after coincidence is no coincidence at all. It's a pattern, and it's a pattern that the defendant knew that she had the means and methods to carry out. Now, we don't know exactly what happened on August 18th of 2012, but we know some things. We know that the defendant found a way to get rid of her husband. We know that she and her brother, they found a way to get rid of his body, maybe in that industrial grade meat grinder that fits human bodies. We know that they found a way to get rid of the evidence, perhaps in a way that a deputy sheriff would know how to. And we know that they went ahead and they dumped Lou's van at a nearby airstrip, so it looked like he went flying and then drove back just in time to have a purported alibi. The defense, they're going to try to tell you, well, we have absolutely no physical evidence to prove that any of this happened. And they're right, because that was the plan. Today, we learned that the defendant doesn't have just any animal sanctuary. She has a big cat sanctuary with lions and leopards and tigers who all eat freshly ground meat. We learned that she had an industrial grade meat grinder that fits a human body, and it takes 2 to operate. And then it just happens on the night of August 18th, the exact time that Lou Donaldson went missing. Well, the defendant had 2 people. And not just a stranger or an employee, but her brother, a deputy sheriff who would know how to operate it. The defense, they wanted to tell you that the defendant, she went out for milk and formula. They want to tell you it just happened to occur at that time, despite the defendant knowing that tiger cubs, well, they need milk and formula for weeks after their birth. They want to tell you it's a second coincidence that the defendant just happened to drive to a grocery store with no receipt of her there, no no bag boy to tell her that she was there, no canceled check, no credit card bill. They tell you it's a third and a fourth coincidence that she didn't have her phone, that her car broke down despite no record of it. They tell you it's a fifth and a sixth coincidence that she can't tell you the driver that night, that she has no idea who it was or their phone number. They tell you it's more coincidences that we have no receipts of the car breaking down that night. But members of the jury, coincidence after coincidence is no coincidence at all. There's no evidence because it's in a tiger's belly and in the bleach and towels that a sheriff's deputy would know would get rid of blood. The defense, they tried to tell you it was either a plane crash or that Mr. Donaldson is in Costa Rica sitting pretty, but members of the jury, think about what they actually proved to you today. Not a single piece of debris, not a single person who saw that plane, not a single person at the airport who knew that Lou Donaldson went to that airport, nothing. And that's exactly it. Now, if you do find for the plaintiff on liability, you're going to have to assess something called damages. We're asking that you reimburse Cam Donaldson for the $5 million estate, the $5 million life insurance, the deed to Wild Wildlife Sanctuary, and for pain and suffering for his loss, because today we learned that it was a loss. We learned that he lost his father after years of working with him, being his only son, and lost out on his inheritance. That's why we're asking you for all that money. And is it a lot of money? Absolutely. But just because life is priceless doesn't mean it's worthless. Now, the defense is going to stand up and they're going to give their closing argument, and I'm confident that they'll come up with a story, but find Karen Baja liable. Thank you.
Thank you, counsel. All right, defense, you may begin your closing argument.
Thank you, Your Honor. And I don't anticipate needing it, but on the off chance, could I please have an oral 1-minute warning?
Certainly.
Thank you, Your Honor. Members of the jury, this case isn't about happenstance. It's not about coincidences. Opposing counsel is right. This case is about patterns. The patterns that defined Lou Donaldson's life, the decisions he made, which culminated in his final disappearing act. Off the books, off the grid, off the hook. That's what this case comes down to. Lou Donaldson lived his life off the books, secretively sneaking off to Costa Rica with somebody as close to him as his son, none the wiser. He dropped off the grid, intentionally or accidentally. Lou Donaldson left and never came back to his loving wife. But before his final disappearing act, Lou Donaldson wanted to be off the hook. So to feel less guilty for abandoning her, for running away to Costa Rica to be with a mistress, he made sure that Miss Baja was taken care of in his will. The plaintiff's case is a paper tiger, a scary sounding scheme without substance, contrived by an angry and jealous son who is unable to accept his father's decisions. Members of the jury, at the end of the day, Lou Donaldson's disappearance is just that, a disappearance. Nobody knows, and based on how Lou Donaldson decided to live his life, nobody could know where he really disappeared to. As my co-counsel, Karna Kajar, told you at the beginning of trial, my name is Robert Fairbanks, and I have the privilege of representing the defendant in this case, Ms. Karen Baja. And before we talk more about how Lou Donaldson lived his life off the books, off the grid, and ultimately wanted to be off the hook, I want to talk to you a bit about the burden of proof, because I want to make sure you have this straight in your mind, especially after hearing the plaintiff's argument as to what my client didn't prove. Because the plaintiff, Cam Donaldson, brought this case, he carries all the burden of proof. Ms. Baja doesn't have to prove anything. That's important. I'm going to repeat myself. Ms. Baja doesn't have a burden. She does not have to prove anything. That's critical to remember. The plaintiff carries all the burden for every single element. Each one, he is required to prove it to you, the jury, by a preponderance of evidence. So to prevail, he must convince you that each and every element of his claim is more likely true than not true. So that means that at the end of all of this, if you feel like there just isn't enough evidence one way or the other, if you feel like it's a coin flip, a 50-50 chance on any single element, then the plaintiff has failed to meet his burden. And when we do look at the evidence, you'll see that the plaintiff falls far short of meeting his burden for the two most critical elements of his claim. The plaintiff brought his claim under the Statesville Wrongful Death Act. So to carry his burden, the plaintiff had to prove four things to you, all four. 1, Lou Donaldson is dead. 2, his death was intentionally or recklessly caused by Ms. Baja's conduct. 3, the plaintiff suffered injuries, damages, or losses as a result of Lou Donaldson's death. And 4, the plaintiff's injuries and damages were caused by Ms. Baja's intentional or reckless conduct. I'm going to focus on the first two elements because the plaintiff's inability to establish those two renders the rest irrelevant. I'm then going to briefly touch on that last element, which sheds a little light on why the plaintiff brought this claim. So the two key elements the plaintiff failed to prove to you are 1, Lou Donaldson is dead, and 2, if Lou Donaldson died, his death was caused by Ms. Baja's intentional or reckless conduct. The plaintiff took the first element for granted, but members of the jury, you should not. Being legally declared dead is a far cry from actually being dead. When we look at the first element, I want you to focus on Lou Donaldson's off-the-book lifestyle and ask, how likely is it that Lou Donaldson is even dead? How can we know? After everything you've heard and seen today, what do we actually know about Lou Donaldson? What did Lou Donaldson do to live life off the books? The plaintiff claimed he knew everything about his dad's business. He told you he scheduled all of Lou Donaldson's meetings, he wrote the checks, he answered the phones, he ordered the supplies, he ran the books. Lou Donaldson was totally off the books, content to operate in the background and let his son handle the public side of his business for him. And despite doing the books for Lou Donaldson, there were still things that his dad kept completely off the books, secret from even him. The plaintiff admitted to you there was a lot Lou Donaldson kept secret. Nobody knew how many planes he had. He bought and sold planes, but didn't always properly register them. He didn't have a valid pilot's license. The plaintiff told you that his father would sometimes fly without logging a flight plan. Flying without a flight plan, that's about as off the book as you can get. And Ms. Baja corroborated what the plaintiff told you. She agreed that Lou Donaldson was a private and secretive man at war with the strength of their marriage. Based on his off-the-book lifestyle, Lou Donaldson could be alive and well without anybody in this case being remotely aware. Now, the plaintiff emphasized some bank records, an account with about $100,000, which he says is proof Lou Donaldson must be dead because otherwise, why haven't there been any withdrawals? The plaintiff is trying to keep you from using your common sense. Lou Donaldson's estate, you heard today, was valued in the millions of dollars, millions. If he was trying to disappear to start a new life with a mistress in Costa Rica, it would actually be surprising if he had withdrawn money from that account. Think about everything Lou Donaldson kept off the books. Would it be surprising if he kept some accounts off the books, some untraceable funds? Instead of thinking Lou Donaldson is dead because he hasn't touched a relatively small account, it's far more likely Lou Donaldson is living with his accounts off the books, enjoying the beaches of Costa Rica. At the end of the day, because of how off the book Lou Donaldson lived his life, all we really know, all anybody knows, is that he dropped off the grid. Past that, it's pure speculation. But remember, Mr. Baja didn't have to prove anything to you. The plaintiff had to prove to you what happened to him. And they didn't because they couldn't. So members of the jury, the case stops here. Because the plaintiff failed to prove to you the very first element, you have all the information you need to render a verdict in favor of Ms. Baja. But for the sake of being complete, I'm going to continue by talking about how Lou Donaldson dropped off the grid and why he wanted to be off the hook. So what did Lou Donaldson do to drop off the grid? To talk more about when Lou Donaldson dropped off the grid, let's turn to that second element, whether Ms. Baja intentionally caused Lou Donaldson's death. Even if you think Lou Donaldson is dead, the reasons and the way he dropped off the grid show Ms. Baja didn't have anything to do with any of it. So let's start with the reasons Lou Donaldson dropped off the grid. You heard there were family tensions. His privacy and paranoia were testing the strength of his marriage to Ms. Baja. He was taking secret and sudden trips to visit his international mistress in Costa Rica. There was a talk of divorce. You heard about a temporary restraining order. Lou Donaldson wanted out, and he knew that his off-the-book lifestyle would make it easy to just drop off the grid. And let's talk about the night he dropped off the grid. Let's turn to the night he disappeared. From the outset, we don't know what he was doing. Ms. Baja explained to you that she often didn't know what he was doing. For all she knew that night, he was already on his way to Costa Rica, eager to get to his international mistress. Ms. Baja had to run an errand, had some car trouble. Nothing sketchy there. Her brother, who she knew was working that night, picked her up. It was 3 a.m. Even if she had known where her husband was, why would she have called somebody who was probably sleeping? She had a brother who she knew was awake, working, and in the area. And past that, even the plaintiff doesn't have anything to add because nobody, and I mean nobody, actually knows what Lou Donaldson was up to. All we know is that he wasn't with Ms. Baja that night. And what about the temporary restraining order? Well, the court denied it, didn't find the contents credible, and neither should you. We don't know, neither does the plaintiff, what happened after the TRO. The conversations Ms. Baja had with her husband, the details of their marriage, which was complicated and tumultuous, but ultimately defined by mutual care, can only be truly understood by them. So if Lou Donaldson died that night, Ms. Baja had nothing to do with it. If he died, it was during his attempt to drop off the grid. Could have happened when he was flying the airplane. Could have happened when he arrived in Costa Rica. We don't know. We probably never will know. You also heard from the insurance company's investigator, Chris Renard, the most objective person in this entire case, who determined Ms. Baja had nothing to do with Lou Donaldson's death. So if Lou Donaldson is actually dead, which plaintiff has not proven, there is no evidence connected to Ms. Baja. There's no body, no evidence of foul play, no murder weapon. The plaintiff wants to talk to you about a meat grinder. A meat grinder. There was no DNA evidence on that meat grinder, no evidence of a struggle, no evidence of how Ms. Baja would have even gotten Lou Donaldson into that meat grinder. No hard evidence anywhere to suggest that Ms. Baja had anything to do with Lou Donaldson's potential death. Mr. Renard's employer would have loved to find out they didn't have to pay Miss Baja because she was linked to Lou Donaldson's disappearance. But Mr. Renard couldn't give them that because it simply isn't true. Now, I want to briefly touch on the last element of this case. Since the plaintiff did not prove to you that Lou Donaldson actually died or that Miss Baja caused his death, it's not critical to the case. But I think it sheds some light on why all of this is happening. To understand why Miss Baja didn't cause the plaintiff's pain, regardless of whether Lou Donaldson is alive or dead, we need to talk about Lou Donaldson and his desire to be off the hook from all the responsibility in his life before he dropped off the grid. So he wanted to disappear. He'd had enough. He wanted to disappear, drop off the grid, and start a new life. But it was a little bit more complicated than that. He felt guilty. He still cared for his wife. He felt responsibility there. So he wanted to be off the hook for taking care of his wife, and off the hook for taking care of his business. So what did Lou Donaldson do to get off the hook? He changed his will to make sure Miss Baja would be taken care of, despite the issues in his marriage, despite the secrets, despite the mistress. He still cared for his wife. He remembered that he was her Prince Charming. Lou Donaldson didn't want to be. He didn't want to be on the hook. He couldn't be on the hook for her losing her lifestyle, her house, and the cat she cared for so much. He couldn't do that. So he changed the will to make sure he was off the hook, to make sure she'd be taken care of. That's what he wanted, and that's what happened here. And the plaintiff's hired expert, Miss Pride, tried to raise some doubts about the authenticity of the will. Well, to begin with, think back to what she told you on the stand. Miss Pride told you that she couldn't remember the kinds of cases she'd investigated in the course of her professional career. It turns out she had investigated murders at some point, but during today's trial, she seemed unaware of that experience until she read her own report. Maybe that's why she didn't look into the details of Mr. Donaldson's disappearance. She repeated again and again, I didn't personally look into it. She didn't even talk to the defendant, the person her client accused of being responsible for Lou Donaldson's disappearance. And what did the same investigator say about the will? Well, she told you if the signature looks different than the samples, it might be a forgery. Also said that if it looks the same, it might also be a forgery. Well, it sounds like the plaintiff brought you an expert who was just looking for a forgery, no matter what. And remember, the third-party expert from the insurance company, Ms. Renard, concluded the will was legitimate and the insurance policy should pay out to Ms. Baja. We all know insurance companies look for ways out of paying, but they couldn't find one here because Ms. Baja had nothing to do with Lou Donaldson dropping off the grid. The plaintiff brought up some letter, a letter that Ms. Renard told you she did not think was credible. She wasn't even sure who it came from. There was no reason for Ms. Renard to trust it. She didn't use it to come to any decisions in a report, and there's no reason for you to trust it. Now, Lou Donaldson's choice to be off the hook made the plaintiff feel abandoned and angry. And I think we can all understand that. Cam Donaldson did a lot for his father. He cared for him. We all got to see today how hurt Cam felt when he wasn't included in his father's will. The plaintiff feels that he deserves something for the work he did on Lou Donaldson's behalf. Maybe he's right. But his dad didn't feel that way. And now the plaintiff, unable to accept his father's choices, has directed his anger at Miss Baja. The plaintiff admitted he hates Miss Baja. He, in the past, said that he wishes that she would be attacked and eaten by one of her tigers. Attacked and eaten by one of her tigers. That resentment didn't come about because of his father's disappearance. The plaintiff waited 5 years to hire an investigator to look into his father's disappearance. 5 years. Why didn't he hire one right away if he was so convinced Miss Baja did something? Why did he wait 5 long years? It's because it ultimately wasn't about Miss Baja or his father's disappearance. It was about the money. He hired an investigator when the insurance company was going to pay out. This whole case goes back to the plaintiff's jealousy. It's been there festering and growing, consuming him since Miss Baja entered his father's life, and he felt that first pang of jealousy, that realization that somebody else might get his father's money and property that he covets so much. That's probably why Lou Donaldson never told his son about his mistress. He didn't want to give him another target for his hateful jealousy. So that's the lens we need to look at this entire case through, the motivating force behind the plaintiff's wild allegations. Any damages or injuries suffered by plaintiff were not caused by Miss Baja. Sadly, they were caused by his father's choices. His choice to travel, change the will, and his desire to be off the hook. So to sum things up, the plaintiff had to somehow prove to you that it was more likely than not that Lou Donaldson is dead. Even if he could do that, he also had to prove to you that it was more likely than not that Miss Baja intentionally caused his death. Plaintiff didn't prove anything because he couldn't prove anything. The evidence just isn't there, no matter how angry and jealous he is. There is no murder weapon. There is no body. There is no credible theory as to how, when Miss Baja would have even killed him. Members of the jury, you are here today to decide if my client is responsible for Lou Donaldson's death. And the plaintiff didn't even prove to you that Lou Donaldson is dead. Off the books, off the grid, off the hook. That's the pattern this case is about. After all the testimony, all of the evidence, the plaintiff's case creates far more questions than it answers. And it was their burden to answer them. And they didn't. So I ask you, apply your common sense to what we do know and think about what this case comes down to. Lou Donaldson intentionally lived his life off the book. He dropped off the grid and nobody knows what happened to him. We probably never will. And before he dropped off the grid, he wanted to be off the hook. He wanted to make sure Miss Baja and his business would be taken care of. So he changed his will to reflect that. We can't hold Miss Baja responsible for Lou Donaldson's choices. And no amount of misplaced anger from the plaintiff should change that. Find Miss Baja not liable.
Thank you, counsel. And no rebuttal argument here. All right, as you guys know, because of the prior 3 rounds, we're not going to get comments here. We'll log in, we'll give the comments, you'll get the scores, we'll get the our feedback there. I just want to say as we log out, fantastic job to all the advocates in this round. It was a fun round to watch. I really appreciated everything the council did, working together on different issues. Good luck. This is the last round, right? So unless you're making the final. So good luck on that, I think later this afternoon, whenever that's announced. Thank you guys.
Thank you.